I'll give you how much I have to pay. Now you have to just put things from the page. कितना है? बहुत सारा. Because it's Vadodara. You start with Vadodara. Then whatever you should be after I should be for where to get it first. I'll share with you whatever happens to me. When I start working on that, I'll ask. Hello. Yes, ma'am.
वो राजू का साइन लेने का था ना, लेजर पेपर भी जाओ इसके बाद नहीं आज भी। अरे हाँ अच्छा हो गया आप बोला। मैं अकाउंट पैकेज पे लूंगा पीछे भाई अकाउंट पैकेज
थोड़ा थोड़ा मैं लेती हूँ।
ಪ್ರಯತ್ನ ಮಾಡ್ಬೇಡ. ಅದ ಪೇಪರ್ಸ್ ಅದು ತುಂಬಾ ಸಹಾಯಕಾರಿ ಅಂತ ವಾಟ್ಸ್ಆಪ್ ಮಾಡೋದ್ರಿಗೆ ಅಂತ ಮಂಜು ಸರ್
Not a fresh matter. I filed an IA for posting.
What do you want? What do you want, sir? ಏನ್ ಆಗ್ಬೇಕು ಇವಾಗ ನಿಮ್ಗೆ? ಅಲ್ರಿ ಇವಾಗ ಏನ್ರಿ ಮಾಡ್ಬೇಕು? ಇಸ್ ಇಟ್ ಲಿಸ್ಟೆಡ್ ಟುಡೇ? ವಾಟ್ ಇಸ್ ದಿಸ್? ಕೊಡಿ.
Ex-servicemen who are employed in SBI, their benefits are being withheld. Adike kindly request for a date on.
You don't have to mention separately. Please give it.
There's emergency and interim order. Their benefits have been withheld.
It will come. Yes.
Lord, mandamus, my lord, is sought, my lord, for consideration of the representations made by the petitioners herein. The petitioners herein are erstwhile employees of government soap factory.
There is no interim order. Why do you want to argue, madam?
All the matters not wherein the petitioner counsel has appeared. What can kindly page 1 or 2?
ಅವರೇ ಹಾಕಿದ್ದಾರೆ. ಏನಂತ ಆಗಿದೆ ಅದರಲ್ಲಿ? 102 ನಾ 80 ನಾ?
107.
107.
Current question is 107. This will not state government is directed to consider the representation which they have given.
Later consequential order was also passed and the relief was also granted. But these are also
Why only for the petitioners, is it?
Yes, my lord.
ಆತರ ಆಗುತ್ತೆ.
Only for the petitioners in this.
How can see, even if it is so,
But what in this?
what should the government do?
They have passed an order.
Correct, Amma. How can it be made applicable only to the petitioners?
And what had happened in this case, why it is applicable to only to the petitioners? Some of them have already taken the benefit. So therefore, my lord, those who have already taken the benefit, they are not entitled for. Those who have not taken the benefit and they are ready to refund the benefit which has been taken.
Correct. You have made a distinction between two different categories. If these persons fall under the category where benefit is given, why they also are not given anta prashne? Alva. It is not that you have to drive all the persons to the courts.
Those who have approached this court.
Benefit should be given to all similarly placed persons, Alva. So it can be disposed of. Huh? What was your prayer earlier?
Retirement as per the revised pay rules from time to time that we considered. That was the prayer earlier. For that, not that by the given a representation. Because there was a
Where is your subsequent order?
So it's an annexure D.
Annexure D, page 109. So government order is at page number 118.
Yes.
ಓದಿ ಅದನ್ನು.
ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ 2020 ಹಿಂದಿನ ಸರ್ಕಾರಿ ಸಾಬೂನು ಕಾರ್ಖಾನೆ ಬೆಂಗಳೂರು ಹಾಗೂ ಶಿವಮೊಗ್ಗ ಮತ್ತು ಮೈಸೂರು ಸರ್ಕಾರಿ ಗಂಧ ಎಣ್ಣೆ ಕಾರ್ಖಾನೆ ಕರ್ನಾಟಕ ಸಾಬೂನು ಮತ್ತು ನಿಯಮಿತ ವಿಲೀನಗೊಳಿಸಲಾಗಿದ್ದು ಸದರಿ ಕಾರ್ಖಾನೆಗಳಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಸೋನ್ಸೋರ್ ಇತರ ಕರ್ನಾಟಕ ಸಾಬೂನು ಮತ್ತು ವರ್ಗಾಯಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ನಿಯಮಿತ ಸೇವಾ ನಿಯಮಗಳನ್ನು ಒಪ್ಪಿ ಮುಚ್ಚಳಿಕೆಗಳನ್ನು ಲಿಖಿತ ರೂಪದಲ್ಲಿ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಆದಾಗ್ಯೂ ಈ ನೌಕರರಿಗೆ ಕಾರ್ಮಿಕ ಕಾಯ್ದೆ ಅನ್ವಯ ದೊರೆಯಬಹುದಾದ ನಿವೃತ್ತಿ ಸೌಲಭ್ಯಗಳು, ಪ್ರಾವಿಡೆಂಟ್ ಗ್ರಾಚ್ಯುಟಿ, ಎಕ್ಸ್ಗ್ರೇಷಿಯಾ, ಅಡಿಗೆ ರಜೆ, ನಗದೀಕರಣ ಸೌಲಭ್ಯಗಳು ನೀಡಲಾಗಿದೆ. ಆದರೆ ಇದನ್ನು ಕರ್ನಾಟಕ ಸಾಬೂನು ಮತ್ತು ನಿಯಮಿತಗಳಲ್ಲಿ ವಿಲೀನಗೊಳಿಸದೇ ಇರುವುದರಿಂದ ಇವರು ಸರ್ಕಾರಿ ಕಾರ್ಖಾನೆಯ ನೌಕರರಾಗಿ ಮುಂದುವರಿಯುತ್ತಾರೆ ಎಂದು ಪರಿಗಣಿಸುವ ಸಂದರ್ಭ ಬಂದಿದ್ದು, ಸರ್ಕಾರಿ ರೇಷ್ಮೆ ಕಾರ್ಖಾನೆಗಳ ನೌಕರರು ಮತ್ತು ಕೃಷ್ಣಪ್ಪ ಮತ್ತು ಇತರರು ಮತ್ತು ವೆಂಕಟೇಶ್ ಇತರರಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನಿರ್ದಿಷ್ಟ ಆದೇಶ ಪಡೆದ ನಿವೃತ್ತ ನೌಕರರಿಗೆ ಮಾತ್ರ ಪಿಂಚಣಿ ಸೌಲಭ್ಯವನ್ನು ವಿಸ್ತರಿಸಿತ್ತು. ಅದೇ ರೀತಿ ಪ್ರಕರಣದಲ್ಲಿಯೂ ಸಹ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ರಿಟ್ ಸಂಖ್ಯೆ 2687/2021 ಪ್ರಕರಣದಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಮೊರೆಗೆ ಹೋಗಿರುವ ಸೋನ್ಸೋರವರು 35 ನಿವೃತ್ತ ನೌಕರರಿಗೆ ಕರ್ನಾಟಕ ನಾಗರಿಕತ್ವ ಸೇವಾ ನಿಯಮದ ಕೆಳಕಂಡ ಷರತ್ತುಗಳು ನಿಬಂಧನೆಗಳನ್ನು ಪೂರೈಸುವ ಷರತ್ತುಗಳನ್ನು ಪಿಂಚಣಿ ಸೌಲಭ್ಯಗಳನ್ನು ವಿಸ್ತರಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. ಸಂಸ್ಥೆಯಲ್ಲಿ ಇರುವ ಯಾವುದೇ ಮುಂಬಡ್ತಿಗಳನ್ನು ಪಡೆದಿದ್ದಲ್ಲಿ ಅವರೂ ಇದಕ್ಕೆ ಅರ್ಹರಾಗಿರುವುದಿಲ್ಲ ಮತ್ತು ಸಂಬಂಧ ನೀಡಲಾದ ಹೆಚ್ಚುವರಿ ವೇತನ ಬಡ್ತಿಗಳನ್ನು ಮರುಪರಿಶೀಲಿಸಬೇಕಾಗುತ್ತದೆ. ಇವರು ರಾಜ್ಯ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಲಭ್ಯವಾಗಿರುವ ಕಾಲಬದ್ಧ ಮುಂಬಡ್ತಿ ಸ್ವಯಂಚಾಲಿತ ವೇತನ ಮುಂಬಡ್ತಿಗಳಿಗೆ ಮಾತ್ರ ಅರ್ಹರಾಗಿದ್ದಾರೆ. ನಿವೃತ್ತಿ ವೇತನ ಸೌಲಭ್ಯ ಈ ರೀತಿ.
But there is no specific reason why it is restricted only to the petitioners.
That is why it is there in the first paragraph itself. Those who are, that is the word.
Correct. They say.
ಕೊಟ್ಟಿರೋ ಪಕ್ಷದಲ್ಲಿ that is the word used. ಯಾರ್ಯಾರು
Correct, amma. If that was the case. ವರ್ಗಾಯಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ನಿಯಮಿತದ ಸೇವಾ ನಿಯಮಗಳನ್ನು ಒಪ್ಪಿ ಮುಚ್ಚಳಿಕೆಯನ್ನು ಲಿಖಿತ ರೂಪದಲ್ಲಿ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ.
ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೋ
ಅವರು ಕೊಟ್ಟಿರಲಿಲ್ಲ ಅಲ್ವಾ? ಮತ್ತೆ
even this petitioners were approached.
Correct.
Earlier this
ಕೊಟ್ಟಿರಲಿಲ್ಲ.
They have not given. Later on, my lord, when ಅಲ್ಲಿ ಸಿಲ್ಕ್ ಡೆವಲಪ್ಮೆಂಟ್ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಒಂದು ಸಿಮಿಲರ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದಾಗ these people have approached.
Correct. ಆದ್ರೆ why is it restricted only to the writ petitioners ಅನ್ನೋ ಪ್ರಶ್ನೆ. There is no specific reason assigned why it has to be restricted only to the petitioners. Alva.
That is true, my lord, but what had happened, my lord, sometimes, my lord, without
people
unless the court orders are there.
People who are taking decision, they should be aware of how the law operates. It's a simple situation where you are deciding the case of certain persons who, even according to you, had not given the undertaking. If there are other similarly situated persons, why the benefit is not given to them? Another question. If there is any specific reason, no, it has to be restricted only to the petitioners and Buddha. I can understand. There cannot be such a restriction. But ಇವ್ರಿಗೆ
MRC Ravi. MRC Ravi appears. Let him also appear.
Alva.
Let him also appear.
Learned AGA takes notice for respond number 1. Learned Council Shri MRC Ravi. Learned AGA for response number 1 and 3.
1 and 3.
Learned Council Shri MRC Ravi is directed to take notice for respond number 2.
Mr. MRC Ravi is now senior designated counsel. Mr. Prashant may be directed.
Prashant. Prashant VR. Directed to take notice for respond number 2. Learned Council for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on Learned Council for respond number 2 and a copy on the Learned AGA. Stop. Next para. Since the matter stands covered by an earlier decision of this court in WP number 8320 of 2020 dated 6th of March.
2687. Considering 2687 of 2021, Lordship can kindly see 119, page number 119.
There is reference to 2 decisions.
Yes, there are.
Reference
Page number 119.
Allah, that is only 2687. What about 8320?
Similarly placed persons, my lord.
Huh?
These are other sets of writ petitions, my lord. Same relief was sought.
8320 is also same. Reference is an Annex D 109.
109.
109 Annex D.
Allama, this decision in 8320 of 2020 at Annexure C,
Yes, yes.
was it a subsequent order based on 2687?
This is the Annex D, page 109.
Yes, my lord. For the first writ, my lord, seeking the same relief was filed on 27th March 2015. That is at Annexure A, page 25.
When was this 2687 of 2021 decided?
March 2021. Annex C.
Illama, not 8320. I am asking of 2687. Twenty-four 2021. You'll find that at page number 117. 24 2021. So that is after this 8320. You have not produced that copy.
Lord, it wasn't available. We have produced the other two decisions.
Matters of an earlier decision of this court in the book number 832020 dated 6/3/2021.
And WP number 2687 of 2021 dated 20th of April 2021. And thereafter, in terms of the directions issued therein, government order dated 11/2/2021. Dated 19/11/2021 and correct 11/2/2021 and 19/11/2021 were passed by the first respondent state government, giving the benefit of provident fund, gratuity, ex gratia, relief for VR employees, close, earned leave, encashment, etc. The petitioners herein contend that the similar benefit is to be given to them as they are similarly placed. Stop. Next para. Release this matter on 22nd of March 2022. Please serve a copy today.
The petition has given complaint
since my lord, the suspended CEO and the vice president are running the administration parallelly. As the next J, my lord, a notice has been issued on section 29C to take an action as contemplated section 29C subsection 8. So far, my lord, no action has been taken. Just I'm seeking a direction, my lord.
Yeah.
To dispose of.
I didn't get your
My lord, the petitioner is the
primary
president of
cooperative
society.
primary petitioner is a primary cooperative society.
Represented by the president.
Ah,
My lord, the petitioner was elected as the president on 29/10/2021.
sir, it's not the president. It's not the petitioner. If that was your contention, it should have been filed by the president. It's not filed by the president.
By president.
The writ petition is filed by the society.
By its president, Mahesh.
That cannot be done, sir. That is not the way. If you are seeking an individual relief as the elected member, then this writ petition should have been filed as such. That is not the way it is filed.
Then I will.
ಆಯ್ತು ಹೇಳಿ ಮುಂದೆ ಹೇಳಿ. What is it? What is
One my lord, a note, Rashma kindly say, my lord, one Nandish was the CEO.
Ah.
He has been kept under suspension.
Ah.
In spite of the fact, my lord, that he has been kept under suspension, he has been calling the notice after notice in collusion with the vice president and has also called the general body meeting, though the president was in existence. Therefore, the complaint was lodged by the president to the respondent to take action. As per Annexure J, my lord, a notice has been issued to take action as against the suspended secretary and the vice president on 23/12/2021. Therefore, I am seeking a direction, my lord, pursuant to this notice, that the respondent take action because it is a financial institution. If the suspended secretary and other persons run a parallel management, my lord, it affects the credit. It is a credit cooperative society. Only, my lord, a direction to take action pursuant to the notice issued by the respondent. Annexure J is the notice, my lord. H1, H2 are the complaints lodged by the petitioner. Annexure B, the Nandish was suspended as per Annexure B, my lord, on 6/12/2021. Tumkur DCC Bank has also deputed an official in place of CEO, and he has not been given charge. And he has been calling the notice in the name of vice president. So the
usually a cooperative society is represented by whom?
Secretary, usually
Secretary. Secretary and the ಬೇರೆ ಇದಾರಾ?
ಅಲ್ಲ CEO ಇವಾಗ ಮತ್ತು CEO ಅಂತ ಸಾಮಾನ್ಯವಾಗಿ society would be represented by CEO. The last piece. But here, my lord, since I am the elected president,
Sir, nothing prevented you from filing a writ petition
that is 2 minutes.
in your own name. You
RS
can't make use of the name of the society.
ಅಲ್ಲ ಅದನ್ನ ಬೇಕಾದ್ರೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ಮಹೇಶ್ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ ಬೇಕಾದ್ರೆ ಚೇಂಜ್ ಮಾಡಿ.
Learned AGA takes notice for the respondent. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned AGA. Good stop. Next para. Learned AGA is directed to secure instructions from the
Association of Cooperative Societies
respondent as to why no further action is taken consequent to the notice dated nil
ಅಲ್ಲ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ
12/2021 at annexure J. At 23/12/2021 at annexure J, seeking to take action against the vice president
and the suspended secretary, suspended CEO,
suspended CEO
Nandish by name Nandish,
of the Primary Agricultural Credit Cooperative Society Limited, comma, in terms of section 29 capital C
subsection
for
A.
disqualification. So, release this matter on 24th of March. Huh? If he says action will be taken immediately, we can close the case.
Serial number 3. I appear for the petitioner's counsel.
Yes, sir.
The petitioner is working as a professor of civil engineering in the respondent university. The issue that arises for consideration is as to the petitioner's eligibility to become the president of the civil engineering department in the respondent university. The petitioner was promoted as professor, rather directly recruited as professor under the backlog category on 25/7/2019. The only other professor had completed his term of tenure of 2 years, and it is to be given by rotation. It is to be given only among the professors. Denying the benefit of that appointment, one Mr. Ravi Kumar was appointed. That Ravi Kumar is not a professor. He is beneficiary of a what is called as career advancement scheme, initiated by the UGC as a stagnation relief measure. That is a promotion from one pay scale to another pay scale, not a promotion to a post in the cadre. That is well settled by the Honorable Supreme Court also. Be that as it may, that Ravi Kumar was appointed. I questioned the validity of the same before this Honorable Court in writ petition number 3610 of 2021.
Page number?
I placed that writ petition copy also before the court. That may kindly be perused.
Where is it?
Yeah, it is placed before the court. The entire set of papers in the connected writ petition are also placed before the court. Be that as it may, in that case, this Honorable Court was pleased to hear the matter substantially. And in the light of an endorsement given by the university itself at page 139, annexure M, may trouble the court, 139. So this is after I was directly recruited under the backlog category. This is after the contesting respondent was given.
Last time ಇನ್ನೊಂದು matter ಬಂದಿತ್ತಲ್ಲ ಇದೇ ತರದ್ದು.
ಅದನ್ನೇ ಹೇಳಿದೆ. I'm glad, grateful to the court. No, in that this annexure M, H.N. Ramesh is the first professor. Dr. Jairamappa, that is the petitioner herein, is the only other professor. There is no option but to give it to me. But that Ravi Kumar,
this is another writ petition, is it?
Yes, another writ petition. The reason is, what we kindly recollect, the term of that Ravi Kumar was coming to an end on 20th March, that is day after tomorrow. Therefore, this Honorable Court did not quash the order, but instead passed an order at annexure N, page 167. Page 167. Order dated 2/3/2022. It's a very short order. May read the.
Yes.
Learned senior so-and-so, appearing for the petitioner, has drawn the attention of this court to annexure M, which is an endorsement dated 24/7, issued by the Chief Information Officer of the First Respondent, Bangalore University, showing the details of the professors, associate professors, and assistant professors in the Department of Civil Engineering, UVCE, Bangalore University, as on 10/2/2020. The Learned Senior Counsel submits that there are only 2 professors. One, Dr. H.N. Ramesh, who has since attained the age of superannuation. I stand corrected. That is not superannuation. His tenure is over. Since it is by rotation, his tenure is over. He has to make over for another person. The only other person who is professor in the civil engineering department is the petitioner. The second respondent, Dr. A.S. Ravi Kumar, is at serial number 1 among the associate professors. Therefore, the learned senior counsel submits that the challenge raised in this writ petition regarding the appointment of the second respondent as the chairman of the civil engineering department, pursuant to the impugned order dated 25/2/2020, is for a period of 2 years. And since the second respondent took charge as chairman on 20th March 2020, his term will come to an end on 19/3/2022. Nevertheless, the learned senior counsel submits that at least for the next term, the respondent university is required to consider the candidature of the petitioner alone for the post of chairman of the Department of Civil Engineering at UVC, since it is a post on rotation for a period of 2 years at a time. Relist this matter on 25/3/2022 to enable the respondent Bangalore University to take note of the observations of this court and to proceed to make the next appointment to the post of chairman, Department of Civil Engineering, and place the same before this court.
Yes.
Now, notwithstanding this order, with impunity, now the Bangalore University Syndicate passes a resolution, Annexure S, page 341, may kindly be. Annexure 1 at page 341. The relevant parties at item number 80 at page 364. These are the proceedings of the Bangalore University Syndicate.
No, but that is dated. That the proceedings taken place on 9th of February.
Yes.
Much before the order was passed by this court.
No, the confirmation of the proceedings dated 9/2.
Correct. That meeting has taken place even before the order was passed by this court.
May I clarify? That meeting was not held on that day. That was not held on that. Sorry, my lord.
No, sir. No, sir. Even the date on the top is 23/2.
Possibly this was not placed before the court by the Senate advocate for the namgu gottirlilla. But now
where was the need for you to file a fresh writ petition?
No, because a new appointment is made.
Allah, if you see the date,
I agree. I could have made an application in that itself. Since he was not a party to that.
Yes.
Allah, since he was not a party to the earlier proceedings, and this is a new cause of action, I did not want any technical objection to be raised.
Where is the
where
is the operative portion of that?
Kindly come to page 364.
364.
364, item 80.
Civil engineering.
Item 80.
Professor
Elluru Vishwavidyalaya. Yes. L. Manjesh Anta. He is another beneficiary of the career advancement scheme. Therefore, the need to file a fresh petition because he is a new person who was not a party to the earlier.
Anyway, it is evident that this decision was taken much prior to the order passed by this court. Let them come.
In the interregnum, let them not give effect to this.
ಅಲ್ಲ ಆಗೋಗಿದೆಯಲ್ಲ ಅದು ಯಾವಾಗ ಆಗಿರೋದು 23/2
ಅಲ್ಲ ಟರ್ಮ್ ಮುಗಿಯೋದು 20 ನಾಡಿದ್ದಕ್ಕೆ 19/3 second respondent in that writ petition holds the office. That will be vacated only on 20th or 19/3 Saturday. That is the urgency of the matter. Otherwise, I would have waited for the listing of the other case, which is already directed to be listed on 23. As per annexure N, the earlier matter is directed to be listed on 25.3. I would have waited till then, but for the fact this man will take over on 20th. Therefore, the need for an interim order.
Who is appearing for this Bangalore University in the connected matter?
In the connected matter, the Bangalore University was
Ramesh.
Yeah. T.
B Ramesh.
Ramesh. Learned AGA takes notice for respondent number 1. Learned Counsel Shri P Ramesh is directed to take notice for respondent number 2. Issue emergent notice to respondent number 3. The petitioner is also permitted to take out hand summons to respondent number 3. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on Learned Counsel for respondent number 2 and a copy on the Learned AGA. Full stop. Next para. Learned Senior Counsel Professor Ravi Kumar appearing for the petitioner submits that the writ petitioner before this court had already approached this court in WP number 3610 of 2021, raising a grievance in respect of appointment of chairman to the civil engineering department of the second respondent university, which is a post on rotation basis for a term of 2 years.
2 years.
Stop. Noticing the averments made in the writ petition, and more particularly the endorsement dated 24/7/2020 issued by the Chief Information Officer of the Bangalore University, this court was prima facie satisfied that after the completion of the term of Dr. H.N. Ramesh, who is presently occupying the post of chairman of the civil engineering department.
Presently occupying Ravi Kumar. Presently occupying is by the
Ravi Kumar, Dr. A.S.
Ravi Kumar.
Yes, Ravi.
The only person available to be appointed from the cadre of professor is the petitioner. Therefore, by order dated 2/3/2022, this court had directed the respondent Bangalore University to take note of the observations of this court and proceed to make the next appointment to the post of chairman, Department of Civil Engineering, and place the same before this court. Stop. The Senior Counsel said submits that by the impugned order, the impugned resolution dated 23/2/2022 at annexure S, the syndicate has taken a decision to appoint the third respondent, Professor L. Manjesh, as the chairman of the Department of Civil Engineering at the second respondent, Bangalore University. So, however, what is to be noticed is that the resolution is dated 23/2/2022, much prior to the interim orders passed by this court. So, nevertheless, it has been pointed out by the learned senior counsel from the information supplied by the Chief Information Officer that the third respondent is not in the cadre of professor, and therefore, even as per the regulations of the respondent university, preference is required to be given to the professors to be appointed as chairman of the department. Stop. Therefore, the second respondent university is hereby directed not to give effect to the resolution dated 23/2/2022, till the next date of hearing. Full stop. Relist this matter on 24th of March.
Before I appear for the petitioner's counsel, my lord.
Yes.
A proceeding under section 69 of the 69, that is surcharge, was taken against which an appeal is filed, and the appeal is being heard by the Karnataka Appellate Tribunal. Actually, the arguments are over. Matter is posted for on 24th, 24/3 for reply, if any. In the meanwhile, one of the present petitioner was one of the member of the board of directors. Against him, repeated execution was taken for sale of his property. It did not materialize. Now, order under section 101B is issued, page 80. To transfer the property to the so-called decree holder society, 101B. Appeal is, hearing is over. It is posted to 24/3 for reply, if any. 101B, kindly see the provision, Mala. One of the grounds raised is there is no apportionment made. Dues is supposed to be 32 crores and odd. There are as many as 20 board of directors. There is no apportionment made. Now the proceeding says you pay 32 crores. Otherwise, property will be transferred to the decree holder. Such an action, as per their order itself, it says it's a decree, joint decree.
Yes.
101B may kindly be seen.
Yes.
Subsection 2. Where the property is transferred to the cooperative society. Now they want it to be transferred to cooperative society without fixing any price. As there were no bidders, it is transferred to cooperative societies. Even if they are to transfer it, then they will have to say either partial satisfaction or full satisfaction, or for what amount.
Which provision, sir?
101 capital B.
Howdo?
When in any execution of an order sought to be executed and 101, any property cannot be sold for want of buyers. If such property is in the
101, 101B.
1.
When
in any execution of an order sought to be executed under section 101, any property cannot be sold for want of buyers. If such property is in the occupancy of defaulter or of some person on his behalf, or of some person claiming under a title created by the defaulter after issue of the certificate by the registrar, or any person authorized by him under 101, the court or the deputy commissioner or the registrar, as the case may be, notwithstanding anything contained in any law for the time being in force, direct that the said property or any portion thereof shall be transferred in the manner prescribed to the cooperative society which has applied for execution.
Yes.
The order now says, page 80, that it was brought to auction. There were no bidders, it could not be sold.
Correct, sir. But where is the provision does not state that it has to be determined. It has to be apportioned. It has to be determined. Only then you can.
Property is already attached.
Yes.
Attachment is subsisting.
Yes.
Now, in spite of attachment and the proceedings for sale,
yes,
there were no bidders.
Yes.
Now, they cannot take over my property. Yes, they can take over for some value or for the liability.
Sir, the distinction that you are trying to make is not evident from the plain reading of the provision.
Otherwise, neither the loan, neither there is repayment of loan. Kindly see the last words in that, my lord.
If there is an apportionment done subsequently, and you are made liable to pay only a portion of it, then they will give back whatever money is not to be taken from you.
Page 80, order in the last portion, impugned order in the last portion. ಆದ್ದರಿಂದ ಏನು page 81.
Yes.
ಆದ್ದರಿಂದ ಈ ನೋಟಿಸ್ ತಲುಪಿದ 1 ತಿಂಗಳೊಳಗಾಗಿ ಡಿಕ್ರಿದಾರರು ಬ್ಯಾಂಕಿಗೆ ಆಗಿರುವ ನಷ್ಟದ ಮೊತ್ತವನ್ನು ಪಾವತಿಸಲು ಸೂಚಿಸಿದೆ. ತಪ್ಪಿದಲ್ಲಿ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 101B ಅಡಿ ಡಿಕ್ರಿದಾರರ ಬ್ಯಾಂಕಿನ ಹೆಸರಿಗೆ ನಿಮ್ಮ ಸ್ಥಿರಾಸ್ತಿಯನ್ನು ವರ್ಗಾಯಿಸಲಾಗುವುದು.
Yes, but which is the provision that says apportionment should be done? Apportionment should be done.
32 crores ಗೆ either they take it for full satisfaction or partial satisfaction.
Normally, all of you will be jointly and severally liable to pay.
I even consider that. Yes. Now, if the bank wants to take over this property, it should be for some sum or for satisfaction of the decree.
They are saying the entire award amount. They are saying the entire
award amount. ಈಗ ನನ್ನ ಪ್ರಾಪರ್ಟಿನ ಅವ್ರು ತಗೊಳ್ಳೋದಾದ್ರೆ ಅದನ್ನ ಏನೋ ಒಂದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಆಗ್ಬೇಕು.
ಅಲ್ಲ ಅದಕ್ಕೇನೆ ಕೇಳ್ತಾ ಇರೋದು
5 ಲಕ್ಷನೋ 3 ಲಕ್ಷನೋ. Rule 38 may kindly be seen.
Rule 38.
ಹೌದು.
Yes.
This matter pertains to Amanat Bank. I made caveat noticing the submissions made by senior counsel. I didn't want to interrupt. But I think
it has not been noted, is it? Your caveat has not been noted.
CP note ಅಂತ ಇದೆ. ಏನ್ ಮಾಡಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ. ಕಾಸ್ಟ್ ಡೇಟ್ ನಲ್ಲಿ along with CP note ಅಂತ ಇದೆ.
Order not tallying, hence the CP is not put up. Huh?
We had brought this property for sale. Jointly and severally liable on the.
No, it's all right.
You
Please wait. There's no problem. You please wait. Yes. Rule 38.
Rule 38, capital A.
Ah.
A1 if there are no buyers, the registrar can, on a request made by the decree holder, registrar can order for transfer.
Yes.
Sub-rule 2. Consent of the society is sought whether it would like to take over. In this case, they have made application, therefore there is no this thing. Sub-rule 3. On receipt of an application under sub-rule 2, notice shall be issued to the defaulter and to all persons known to be interested in the property, including those whose name appear in the record of rights as persons holding any interest in the property about the intended transfer. Now the notice is issued to the present petitioner owner.
Yes. Yes.
Fourth, on receipt of such notice, defaulter or any person owning such property holding an interest therein by virtue of a title acquired before the date of issue of certificate under 101 may within 1 month from the date of receipt of such notice deposit with the court or deputy commissioner or registrar for payment to the society a sum equal to the amount due under the order sought to be executed, together with interest thereon, and such additional sum for payment of costs and other incidental expenses as may be determined. I am a judgment debtor who is the owner, not
Right.
someone to whom interest is created.
Yes.
Then, on failure of the defaulter or any person interested or holding an interest in the property to deposit the amount under sub-rule 4, the court, deputy commissioner or the registrar, as the case may be, shall direct the property to be transferred to the society on conditions stated in certificate in Form 8.
Yes, sir.
6. The certificate granted under sub-rule 5 shall state whether the property is transferred to the society in full or in partial satisfaction of the amount due to it or from the defaulter. They have to have some value.
No, there is nothing that would mandate that there should be an apportionment. It shall be determined, and only to that extent the sale has to be brought. I don't find anything.
Apportionment alla. I am going to the extent 32 ಕೋಟಿನು ನನ್ನ ಒಬ್ಬನ ಮೇಲೆ ವಸೂಲಿ ಮಾಡ್ಲಿ, ಬಟ್ ಈ ಪ್ರಾಪರ್ಟಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬೇಕಾದ್ರೆ ಇದಕ್ಕೆ ಒಂದು ವ್ಯಾಲ್ಯೂ ಕೊಡ್ಬೇಕಲ್ಲ ಅವರು.
No, that will be done. That will be done at the time of auction.
ಅಲ್ಲಲ್ಲ, ಆಕ್ಷನ್ ಇಲ್ಲ. ಆಕ್ಷನ್ ನಲ್ಲಿ ಯಾರು ಬರಲಿಲ್ಲ, ಅದಕ್ಕೆ ಸೊಸೈಟಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತೇವೆ ಅಂತ, ಡಿಕ್ರಿ ಹೋಲ್ಡರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತೇವೆ ಅಂತ. ಆಕ್ಷನ್ ನಲ್ಲಿ ಯಾರು ಬಿಡ್ ಮಾಡಲಿಲ್ಲ, therefore we want to transfer it to the society, ಡಿಕ್ರಿ ಹೋಲ್ಡರ್. ಎಷ್ಟಾರು ಒಂದು ಅಮೌಂಟ್, ಈಗ 10 ರೂಪಾಯಿಗಾದ್ರೂ ತಗೊಳ್ಬೇಕಾ ಅವರು?
So now they have to determine to what extent it is valued, to what extent it is valued, and to what extent the liability is set off.
It is not already done. It is not. I will take instructions. Not have it on Monday.
Yes, learned AGA takes notice for response number 1 and 2, 1, 2, and 4. Learned counsel Shri Abhinav R, who is present before the court, takes notice for response number 3, Cooperative Bank.
Yes.
Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on learned counsel for response number 3 and a copy on the learned AGA. Next para. since the grievance of the petitioner is that by the impugned notice dated 19/2/2022 at Annexure E issued under section 101 bracket B, read with rule 38A bracket 3 and 4 of the Karnataka Cooperative Societies Act and Rules, where the property belonging to the petitioner is sought to be registered in favor of the third respondent
Transfer.
cooperative bank, transferred, comma. However, no value is fixed on the property to show what is the extent to which the value of the property is set off against the liability of the petitioner. Stop. Next para, learned counsel for the third respondent. No, it is not actually you. It is for the authorities to do it.
The valuation ಆಗಿರಬೇಕು ಅಂತ let them also ascertain, I will also ascertain. Permission will not
The respondent authorities are required to place before this court such clarification as to whether valuation has already been done and to what extent the liability of the petitioner has been set off or is thought to be set off by transferring the property in question. Full stop. Release this matter on 24th of March.
Till then not to transfer. Records change ಮಾಡ್ತಾರೆ.
No. Yes.
ಅಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಚೇಂಜ್ ಮಾಡ್ತಾರೆ ಕಾರ್ಪೊರೇಷನ್ ಗೆ
ಅದು ಹಾಗೆ ಆಗುತ್ತೆ ಸರ್. That cannot be stopped. You only wanted to know what is the valuation.
ಅಲ್ಲ ಅದನ್ನ ಮಾಡದೆ ಮೊದಲೇ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಕೊಂಡ್ರೆ
we do not know. Let us see. Let it come up next week. Yes.
Of the petition, my regulated part of petition, my lord.
Huh?
Petition brother worked in as workshop assistant in Gosha Industrial Training Institute, Rosal Road, from 9th October 1997 till the date of that is 22/2/2015. The service period is 18 years. On 27/2/2015, when the petitioner was driving the vehicle two-wheeler from Bangalore to Tumkur on the way.
There is no interim prayer. There is no interim prayer. There is no interim prayer.
No interim.
The AG takes notice for respondent number 1. Issue notice to respondent number 2. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AG.
For the petitioner, challenging the annexure A. Petitioner is the society formed to encourage and promote the film industry. We are challenging the annexure A, which has been issued by the respondent number 2, the petitioner. Very.
Annexure A is a notice, is it?
Yes, you know. They state the petitioners to conduct the election before April 15th, your Lordship. Before looking into the annexure A, I request your Lordship to see annexure F, your Lordship. Page number 31. On 22 to 2022, the executive committee meeting was been held, and the calendar of events has already been published. Next page, page number 32. Your And finally, on 28/5/2022, as per the calendar of events, the election is going to be held. And as per this annexure,
You want to hold it,
on 28/5/2022.
that is in May.
Yes, sir. Already the calendar of events has been published. And as per annexure H, your lordship, it has been published in the paper, newspaper. And annexure J, it has been published in the notice board. And annexure K, already the place has been booked to hold the election. All these are prior to the letter which has been issued by the respondent number 2. Your lordship, the reason behind to held the elections on 28/5/2022 was bottom page, page number 15.
When was the last election?
Election was on June 2020. It was been held.
2020.
Then, yes, sir. Then due to the COVID reason, the government notification, the election was not able to held. And as for annexure D, your lordship.
When was the last elections held and election to the board has taken place?
Yes, sir. June 2019 was the election, and the term 2019.
2019. Term is for a period of
1 year.
1 year.
1 year.
Matte?
Adadmele government notification due to the COVID reason. Adadmele, as for annexure D, executive committee on 18/12/2021, the calendar of events published to held elections on 16/2/2022. I have produced the annexure D also. Page number 23. This is page number 25. 16/2/2022, the election need to be held. As for this calendar of events, they were ready to conduct the election. But annexure E, the government has again notified to not to hold the elections. As for annexure E, page number 27. Sorry, page number 28. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರಿಕಾ ಕಡೆ ತಮ್ಮ ಗಮನ ಸೆಳೆಯಲಾಗಿದೆ. ಉಲ್ಲೇಖವೊಂದರ ಪತ್ರದಲ್ಲಿ COVID-19 ಎರಡನೇ ಅಲೆಯ ಸಾಂಕ್ರಾಮಿಕ ರೋಗದ ಕಾರಣದಿಂದಾಗಿ ಸಂಘ ಸಂಸ್ಥೆ
That was withdrawn.
Yes, Your Honor.
That was withdrawn later. Yes.
Then subsequently, now annexure F, as per annexure F, the calendar of events has been drawn.
Why such a long time?
As I produced the bylaw, Your Lordship, the bottom page is number 15. Removal and readmission. Every year in the month of April, first week, a notice shall be sent to such members who are in the arrears, intimating them that in case they do not pay the arrears within 30th of April of that year.
ಇದೆಲ್ಲ ಮಾಡೋದಕ್ಕೆ ನೀವು ಆಗ್ಲೇನೆ you wanted to hold the election in the month of February.
The notification January.
But all this exercise would have been completed even at that time.
That was been completed.
Then
due to the COVID, now
ಆಯ್ತು ಗೊತ್ತಾಯ್ತು ಸರ್. What is the difficulty now to hold it earlier?
Prior notices has to be completed as per the
prior notice
rules and regulations bylaw.
When you fix the elections earlier,
yes,
to be held on 16th of February 2022, before that you have completed all this exercise.
But due to the set notification, it was been cancelled. Fresh.
Immediate how many directions we have given to hold it and be completed within a period of 1 or 2 weeks. You can't take advantage of this one and hold it.
Because as per the bylaws,
if it has to be preponed, you please do it and go on with it.
21 clear notice has to be issued. This is page number 41. General body meeting.
Sir, extraordinary circumstances. This court has given directions to continue with the elections that were scheduled earlier. You please go on. There is no difficulty.
But many voters will lose their rights, your lordship. All of us.
That has been determined even before you fix the date of election on 16/2. Only according to that you have to do.
Due to the annexary, we were not able to, and we were not able to collect the subscription fees also.
No.
Because due to the Z order, ಅದು ನಮಗೂ 1 month difference ಇದೆ, 30 days difference ಇದೆ. 15th April ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. 12 ಅಲ್ಲೇ ಪ್ರೊಸೀಜರ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀರಾ ಅಂತ ನಾವು ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ಜಸ್ಟ್ ಒಂದು 25 days difference ಇದೆ.
ಏನಕ್ಕೆ ಬೇಕು?
ಎಲೆಕ್ಷನ್
ಏನಕ್ಕೆ ಬೇಕು ಅಷ್ಟೊಂದು ಡಿಫರೆನ್ಸ್?
Because we need to allow the members to subscribe.
No sir.
There it will be the vote rights of the petitioner members will be deprived of.
No sir.
The constitutional rights will be violated because vote ಕೊಡ್ತಿರಕ್ಕಾಗುತ್ತಾ?
ಹೌದು. You want to include many people who are not on the.
We are not including any.
That is what will. If you want to take more and more time, that is what is going to happen.
ಹೊಸ members ನಾವು
You are prepared to hold the elections in the month of February 2022. What is the difficulty now?
But the subscription fees collect ಮಾಡಕ್ಕಾಗಿಲ್ಲ.
No sir. Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve copies of the petition along with annexures on the learned AGA. No sir.
They might appoint the administrator.
Hardly. If you don't want to hold elections, that is what is going to happen. Yes.
Lord, inquiry for Lokayukta. The BBMP official, my lord, which is said to be bad with the Indian bench. Entrustment and my lord has been stayed. A series of orders of this court, my lord, while directing my lord consideration of promotion. EPC is there tomorrow, my lord.
ಯಾವುದು 4800 ನಾ? of 2022. Same model. ಅದೇ ಫಸ್ಟ್ ಲೈನ್ ಮಾತ್ರ ಇಲ್ಲ.
Yes, sir. But EPC is tomorrow.
Yes, I undertake to file wakalat. Said matter is entrusted to me. On behalf of respondent number 2 members, BBM.
Learned AGA takes notice for respondent number 1. Learned counsel
Sumangala Gachinmat.
Srimati Sumangala Gachinmat takes notice for respondent number 2. Learned counsel Sri Venkatesh Arbatti. Venkatesh Arbatti. He directed to take notice for respondent number 3. Same order. To serve copies.
I appear for the petitioner, my lord. My lord,
Yes.
I pray for a week's time because I was not keeping well. I couldn't go through the papers. My lords may kindly have this matter next week.
Preliminary hearing.
ಹೌದು ಸ್ವಾಮಿ,
2017 matter.
ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು, ಹೋದ್ಸಲ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು, ರಿಸ್ಟೋರ್ ಆಗಿದೆ. ರಿಸ್ಟೋರ್ ಆಗಿ ನಾನು ನಂತರ ವಕಾಲತ್ ಹಾಕಿರೋದು. It was contended that the petitioner is dead anta adu petition was dismissed. Thereupon, as the petitioner was alive, an application was filed and the matter was restored.
What is the difficulty now?
I'm not well. I couldn't go through the papers. Next week, my lord, kindly have it next week.
Sir, for preliminary hearing.
Idu re-auditing.
Matter is today listed for preliminary hearing.
Please, my lord. Re-auditing, it is they are sought for, the petitioner has sought for re-auditing as per annexure D and D1. There was an order for re-auditing as per annexure D and D1, and they are sought for a writ of mandamus to comply by that order.
Idan public interest litigation.
Public interest is
Who are you?
the
Who are
member
you,
of
sir?
Sahakara Sangha. He is a member of Hasiru Sena Raita Karmika Samati Cooperative.
What has that got to do with the fourth respondent? You are not a member of the fourth respondent.
I am not a member.
Then this is in the nature of a public interest litigation.
I'll go through and I'll later
No, sir.
argue.
No. Berkeley. There is no private or individual interest of the petitioner in the matter of the fourth respondent, cooperative society. Stop. If the petitioner is seeking to agitate the matter as a public interest, this writ petition in the present form cannot be maintained. Full stop. Consequently, the writ petition stands dismissed, granting liberty to the petitioner to file a public interest litigation, if he so thinks fit. Full stop.
File the affidavit.
Huh?
The case where Veerappan has got this concept totally file ಮಾಡಿದ್ದಾರೆ. I have received the copy and case of affidavit we should endorsement also. I will
Jenanta.
Cannot be given, but that is the endorsement is the issue. My
My
lord can
Almost
guide.
ಬನ್ನಿ, ಅಣ್ಣ ಕೂತ್ಕೊಳ್ಳಿ.
In case we have file.
ಅಯ್ಯ
Document number-
ಬನ್ನಿ, ಇರ್ತಾರೆ ಡಾಕ್ಟರ್ ಎಲ್ಲ ಹೋಗ್ತಾರೆ.
Document number 2, Lord can kindly document number 2 at page 6. Stated, my lord, that not entitled to, based on the opinion of the RTPS. Reasoning is also given.
You are seeking appointment on compassionate grounds.
That is their mistake.
Adhe.
And special case of is not on the rule based. Because since the police.
Because that benefit was given.
Yes, but what had happened, I placed on record what are the instructions there. There are many cases which are like this type of cases are there. In this case, when the petitioner's father, my lord, he died, and there was an inquiry there. Based on that is also has been taken into consideration. Therefore, this order has been now passed.
Allah, yenanta, what is the opinion?
Opinion is that my lord, he is not entitled for, because in view of the rule, he has not given the application.
That is on compassionate appointment. The benefit was announced by the state government in respect of all persons involved in the operation. So therefore, on that ground, adunna helbekagittu.
ಕೊಟ್ಬಿಟ್ಟಿದ್ರು ಅದಕ್ಕೋಸ್ಕರ therefore I couldn't give it. But they didn't challenge it, not tell. That is, this order was this endorsement was issued on 27/1/2022. This was not communicated to.
You please take this copy.
Yes.
You want to file a rejoinder, you please file it. Then we'll consider.
Taken up on that 24th.
Consequent to the directions issued by this court, the learned AGA has furnished an affidavit dated 16th of March 2022 of the Additional Chief Secretary to the Government, Department of Home, along with copy of the recommendation letter dated 25/6/2020 from the DG and IG, and endorsement dated 27/1/2022 communicated to the DG and IG on 27/1/2022.
27/1/2022.
Stop. A copy of the same is furnished to the learned counsel for petitioner. Learned counsel for the petitioner seeks for a short accommodation to file his rejoinder or objection to the affidavit. Full stop. Accordingly, list this matter after 2 weeks.
24.
Huh?
24.
On the 24th of March.
Kind submission. It's a cooperative society's matter. Mistakenly it has to be registered under service matter. That's the brief facts of the case, my lords.
Office is directed to classify the matter as cooperative society and not a service matter. Yes.
The brief facts of the case, my lords. The petitioner herein was given notices dated 13/7, thereafter 27, my lords, to explain certain allegation upon her, my lords. Thereafter, on 29/7, she was suspended from her post, my lords, by respondent number 4, my lords. Challenging the same, the petitioner approached respondent number 3, my lords, wherein respondent number 3 was pleased to grant an ex parte interim order, my lords. Annex H-31, my lords, page number 31. Very taking into consideration of everything, my lords, Vadi or he has quoted on reasons, my lords, on page number 32, my lords. That's after that, on 3/12/2021, my lords, the ex parte interim order was set aside, my lords. The lordship will kindly see page number 34, my lords. 33 last line.
Annexure H. Annexure H.
Annexure J, my lords, page number 33 last line. ಅರ್ಜಿದಾರರು ಬ್ಯಾಂಕಿನ ಹಿತಾಸಕ್ತಿಗೆ ಮಾರಕವಾಗುವಂತಹ ಕೃತ್ಯಗಳಲ್ಲಿ ತೊಡಗಿದ್ದು ವಾಟ್ಸ್ಆಪ್ ನಂತಹ ಸಾಮಾಜಿಕ ಮಾಧ್ಯಮಗಳಲ್ಲಿ ಬ್ಯಾಂಕಿನ ವಿರುದ್ಧ ಅನಪೇಕ್ಷಿತ ಸಂದೇಶಗಳನ್ನು ಕಳುಹಿಸಿ ಬ್ಯಾಂಕಿಗೆ ಮಸಿ ಬಿಡುವ ಕೃತ್ಯದಲ್ಲಿ ತೊಡಗಿದ ಕಾರಣ ಬ್ಯಾಂಕಿನ ಹಿತಾಸಕ್ತಿಗೆ ಯಾವುದೇ ಧಕ್ಕೆಯಾಗಬಾರದೆಂಬ ದೃಷ್ಟಿಯಿಂದ ಅರ್ಜಿದಾರರನ್ನು ಸೇವೆಯಿಂದ ಅಮಾನತುಗೊಳಿಸಲಾಗಿದೆ. But the allegation against the petitioner here in my lords, that she was taking the pictures of her computer, my lords. The order passed by respondent number 3 is nowhere related to petitioner, my lords. Due to some extraneous consideration and the arbitrariness, the lordship may kindly see. Annexure E, my lords, page number 24, my lords.
No.
Yes, my lords.
You said as per Annexure H,
Yes, my lords, that is the order passed by
appellate authority
yes, my lords, joint
had passed an interim order of stay.
yes, my lords, that is
Stay
annexure
of what? ವಿಚಾರಣಾ ದಿನಾಂಕದವರೆಗೆ ತಡೆಯಾಜ್ಞೆ. ಏನ್ ತಡೆಯಾಜ್ಞೆ?
suspension order ತಡೆಯಾಜ್ಞೆ. Thereafter on 3/12/2021, my lords, annexure J. There is the vacate the ex parte interim order that has been granted, my lords.
Why you went again before the joint registrar?
No, my lords. First, an ex parte interim order was granted, my lords,
By
the joint registrar, my lords. Thereafter, the bank
ex parte interim order of
stay, my lords.
Of
suspension order.
You said the appellate authority.
Not the appellate authority.
Huh?
Joint registrar, my lords. ಸಹಕಾರ ಸಂಘಗಳ ನಿಬಂಧಕರ ಕಚೇರಿ.
You said the appellate authority.
No, my lords. Dispute and
You approached the chairman, disciplinary authority.
no, my lords.
You did not approach the disciplinary authority.
He has passed
You approached the joint registrar.
yes, my lords. Joint registrar of cooperative societies.
There was an interim order passed.
Yes, my lords.
And thereafter it was set aside
Set aside, my lords.
at the instance of the bank.
Bank, my lords. After bank puts in appearance, it has been set aside, my lords. The reasons given there is that, my lords, I have been involved in sending messages to WhatsApp and other social media, my lords. But the lordship may kindly say.
Anyway, this court cannot go into all these aspects now at this stage. It's an order of suspension.
Yes, my lords.
Yes.
The grounds made out before this.
Disciplinary inquiry will be conducted against you, sir.
Yes, my lords.
You participate.
Lords, kindly direct respondent number 3 to expedite the matter, my lords. Time limit may be fixed, my lords.
All right. No. Who is conducting the inquiry?
Inquiry
it has to be conducted by the bank.
Respondent number 4, my lords. But since a dispute is pending for respondent number 3, my lords, dispute regarding the suspension order, my lords.
Correct.
That has been challenged before respondent number 3, joint register of cooperative society.
Yes.
The dispute is still pending, my lords. The order was an interim order. So kindly direct the respondent number 3 to expedite the disposal of the case, my lords.
ಅದ್ರ ಬದಲು disciplinary proceedings ಮುಗಿಸ್ಬಿಡ್ಬೋದು. You go on harping on this one, it will be delayed. The inquiry itself will be delayed if you are asking for disposal of this matter.
They're carrying on the inquiry, my lords, the disciplinary authority. But we challenge the very issuance of notice as well as the suspension order, my lords, before the joint register of cooperative societies. Therein an interim order was passed, staying the suspension order, my lords, at first instance. Thereafter, same was vacated, my lords, without assigning the reasons. And before this honorable court, challenging the interim vacation of the interim order without any assigning any reasons, my lords, on the ground of arbitrariness and capricious nature.
Notice issue ಮಾಡಿಲ್ಲ ಇದರಲ್ಲಿ. Notice ಆಗಿಲ್ಲ. Learned AGA takes notice for response number 1 to 3. Issue emergent notice to response number
4, 5 and 6.
4, 5 and 6. Or if you do not want notice to be issued to the other respondent, I will record your submission and dispose of the matter, directing the joint registrar to dispose of the matter. Notice to respondents number 4 to 6 is dispensed with for the following reason. Next paragraph. The petitioner, aggrieved by an order of suspension passed by the fourth respondent, Cooperative Bank, where the petitioner is working as
accountant, my lords.
An accountant. The petitioner approached the third respondent,
Yes, my lords.
joint registrar of cooperative societies, in proceedings bearing number UBC 3/DIS/612/2021-22, challenging the order of suspension.
Yes, my lords. Order of suspension.
Stop. Initially, the third respondent passed an order dated 26/8/2021, staying the order of suspension. Stop. However, at the instance of the fourth respondent, Cooperative Bank, the joint registrar proceeded to recall, to vacate the interim order of stay, and therefore the petitioner is before this court. Stop. Next paragraph. After arguing for some time, the learned counsel for petitioner submits that it would suffice if this court were to direct the third respondent, joint registrar of cooperative societies, to consider the dispute raised before the joint registrar and dispose of the matter at the earliest. Full stop. Next paragraph. Consequently, this writ petition stands disposed of. while directing the third respondent, joint registrar of cooperative societies, to dispose of the dispute raised in so and so by the petitioner, as expeditiously as possible, and at any rate within a period of
2 months, my lord. It's already in the stage of evidence, my lord. 2 months, my lord.
2 months from the date of receipt of a certified copy of this order. Ordered accordingly.
There is another matter before your lordship, my lord, which has not been listed today on the same grounds, my lord. Same order.
Iದೇ petitioner ta.
Already petitioner change ಇದ್ದಾರೆ, my lord. ಮತ್ತೆ
ಕೊಡಿ ನಂಬರ್ ಕೊಡಿ. Yes.
I appear for petitioner in this matter, my lords. But the petitioner is a retired junior engineer, my lords. Lords, he was granted one career advancement increment in the year 2014. Lords, that came to be withdrawn, my lords, and benefits have been settled, my lords.
No entry prayer.
No entry prayer. What respondent number 1 and 2, Nagashri madam appears, my lords. For respondent number 3 to 6, my lords. Discom Girija Patil.
Learned Counsel Srimati MC Nagashri is directed to take this for response number 1 and 2. Learned Counsel Srimati Girija Patil, who is present to video conference, undertakes to file wakalat for response number 3 to 6. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on the learned counsels for the respondents.
Much obliged.
Much obliged.
The petitioner, my lord. Petitioner, my lord, was working as an assistant manager in a bank and he has been dismissed from service, my lord, and it has been confirmed by the appellate authority. The reason for dismissal, my lord, is that during his tenure, my lord, 6 to 7 customers had filed a complaint stating that they had not withdrawn any money. Somebody else have misrepresented and withdrawn the money, my lord. An inquiry was conducted, my lord. And since I was the assistant manager, my lord, I was held responsible, stating that I should have been cautious and I should have verified it properly, my lord. One main ground, my lord, here, my lord, the person, the petitioner had represented himself in both the inquiry and the appellate authority.
You have not been working from 2020.
Yes.
How can this
one important aspect, my lord? None of those complaints.
But how can this interim prayer be granted, sir?
But in this, none of the complainants were examined at all.
All right, we will see. Is anyone appearing for this Karnataka Gramin Bank, or will issue notice? Issue notice to the respondent.
Just quite admitted as professors in the aided colleges in Bangalore. They have deputed to different colleges by the government. Now they have been paid the HRA, house rent allowance, at the place of the leave, that is the place of posting. On deputation, now they wanted to recover that amount as per Annexure AN, page 85. A circular has been issued. It is totally as per the government order only, the state benefit was being paid, page 85. This commissioner has issued this circular.
Stay agilva idu. Stay agilva idu.
Kindly grant me 2 days, very circular na
Oh, their names are there. But they are now they are covered.
Yaವಾಗ January 2022 ಇವಾಗ
Recovery ಆಗಿಲ್ಲ.
ಅಲ್ಲ ರಿಕವರಿ ಇನ್ನು ಮಾಡ್ತಾರೋ ಇಲ್ವಾ ಅದು ಸರ್ಕ್ಯುಲರ್ my lord. Therefore lordship can kindly have this matter on Monday, my lord. I'll take instruction and make.
Like because
ಆಯ್ತು ಬಿಡಿ ಸರ್, 2 ಸಲ ಏನು ಆಗ್ಬಿಡಲ್ಲ. Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned AGA. At the request of the learned AGA, I released this matter on 21st of March.
Letter. So the petitioner before my lord are elected directors of the milk producing society in Lakkenadi, Bangalore, North Taluk. The body was constituted in the year 2016, and the time period of this body is up till 8/10/2021. 8/10/2021. But in the meanwhile, the government has passed orders and circular notification to postpone because of the COVID. We have much before the expiry of our term, we have passed resolution and we have recommended for elections. In the meanwhile, the reply which they have given and also recommended, my lord will find it at annexure B, C, page number 18. Lakkenhalli Halu Utpadakara Sahakara Sangha Niyamita Lakkenhalli Dasanpur Hobbli so and so. ಸಹಕಾರ ಸಂಘ ಕಾಯ್ದೆ ಕಾಲಂ 28A5 ಅನ್ವಯ ಆಡಳಿತಾಧಿಕಾರಿ ನೇಮಿಸುವ ಬಗ್ಗೆ ಸಂಘದ ಮುಖ್ಯ ನಿರ್ವಾಹಕರು ಪತ್ರ ದಿನಾಂಕ 11/10/21 ಕಚೇರಿ ಸ್ವೀಕೃತ 13/10/21. ಲಕ್ಕೇನಹಳ್ಳಿ ಹಾಲು ಉತ್ಪಾದಕರ ಸಹಕಾರಿ ಸಂಘ ನಿಯಮಿತ ಲಕ್ಕೇನಹಳ್ಳಿ ದಾಸನಪುರ ಹೋಬಳಿ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಈ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ ಚುನಾವಣೆ ನಡೆಸಲು ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಿ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ನೇಮಕಾತಿ ಮಾಡುವಂತೆ ಸಂಘದ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿ ಕೋರಿರುತ್ತಾರೆ. ಹಾಗೂ ಸದರಿ ಸಂಘ ಆಡಳಿತ ಮಂಡಳಿ ಅಧಿಕಾರ ಅವಧಿಯು 8/10/21 ಅಂತ್ಯಕ್ಕೆ ಮುಕ್ತಾಯವಾಗಿರುವುದಾಗಿ ತಿಳಿಸುತ್ತಾರೆ. ಸದರಿ ಸಂಘ ಆಡಳಿತ ಮಂಡಳಿ ಅಧಿಕಾರ ಅವಧಿಯು 8/10/21 ಅಂತ್ಯಕ್ಕೆ ಮುಕ್ತಾಯವಾಗಿರುವುದರಿಂದ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯ ಸಾಮಾನ್ಯ ಚುನಾವಣೆ ನಡೆಸಲು ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ನೇಮಕ ಮಾಡಲು ಸಾಧ್ಯವಾಗದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಸಂಘಕ್ಕೆ ಕರ್ನಾಟಕ ಸಹಕಾರಿ ಸಂಘ ಕಾಯ್ದೆ 28/5 ಆಡಳಿತಾಧಿಕಾರಿ ನೇಮಕ ಮಾಡಲು ಸೂಕ್ತವೆಂದು ಪರಿಗಣಿಸಿ ಕೆಳಕಂಡ ಆದೇಶ ಹೊರಡಿಸಲಾಗಿದೆ. Administrator was appointed in the month of on the recommendation in the month of October 2021. Now afterwards, the very same, because earlier we have passed resolution. Then this executive officer, he was involved in some mischief and scandals in the financial management, where we have made a representation to conduct inquiry. My lord will find it at annexure D, page number 20. Where he has misused checks and also the amount, and his son is also now employed in the same society. These are the allegation. In retaliation of this allegation which we have made, now as a punishment, now the elections have been declared and date calendar of events also now notified. Annexure E is the notification where dates are notified. Now I am taking my lord to annexure F, page number 27. The petitioners now before my lord will find it at the serial number 12.
Elections is to be held on 26th.
26th, but date of filing of nomination is 18th, tomorrow. Now this Matadara Patti, annexure F, my lord. Annexure F, my lord, I will take my lord to the serial number 12, the petitioner's hearing.
ಅವೆಲ್ಲ ಏನು ಮಾಡಕ್ ಬರಲ್ಲ ಸರ್.
ಸರೋಜಮ್ಮ.
No sir. Once calendar of events are announced, we will not.
Election postpone ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. ಇಲ್ಲಿ ಅವ್ರು ಮಾಡಿರೋಂತ ಮಿಸ್ಟೇಕ್ ಯಾಕಂದ್ರೆ ನಾನು ಅವ್ರ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ನಲ್ಲ, ಅದಕ್ಕೆ ಚುನಾವಣೆಗೆ ಸ್ಪರ್ಧಿಸಲು ಅನರ್ಹರು ಅಂತ ನನ್ನ ಹೆಸರು ಮತ್ತೆ ಕಾಲಮ್ ನಲ್ಲಿ ಬಂದಿತ್ತು. ಎಲೆಕ್ಷನ್ ಇದು ದ ಎಲೆಕ್ಟೋರಲ್ ಲಿಸ್ಟ್ ಒಂದು ಅನೌನ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ಅಂತಿಮ ಮತದಾರ ಪಟ್ಟಿ. ಇದರಲ್ಲಿ
when was it announced?
This elections.
No. When was this list published?
List now recently in the that's on 28th or 29th they have published it. The month of February 28th. Now it has come to my hand because he did not release this list also. Now in the end of the matter, now he has released it. Adralli now we have given a complaint and made a serious allegation with this so-called officer. The Karnataka.
There is no reason given, is it? For
reason put it. Annexure G, may I kindly take my lord to annexure G at page number 30. ಇಲ್ಲಿ ಕೊಟ್ಟಿರುವಂತದ್ದು ಲಾಸ್ಟ್ ನಲ್ಲಿ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ 28A5 ಅನ್ವಯ ದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಗಗನ್ ಸೋನ್ಸೋ ನಿರ್ಬಂಧಕರು ಸೋನ್ಸೋ ಬೆಂಗಳೂರು ಸಹಕಾರ ಹಾಲು ಒಕ್ಕೂಟ ನೇಮ್ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ರಾಜಾನಕುಂಟೆ ಆಡಳಿತಾಧಿಕಾರಿ ಅವಧಿಯನ್ನು 8/1/22 ಮುಂದಿನ 3 ತಿಂಗಳು ವಿಸ್ತರಿಸಲಾಗಿದೆ. ಸದರಿ ಅವಧಿಯ ಒಳಗೆ ಸಂಘದ ಉಪ ವಿಧಿ ಹಾಗೂ ಸಹಕಾರಿ ಸಂಘಗಳ ಕಾಯ್ದೆ ಮತ್ತು ನಿಯಮಗಳ ಸಂಘದ ಹೊಸ ಆಡಳಿತ ಮಂಡಳಿ ಪುನರ್ ರಚನೆ ಮಾಡಲು ಅಗತ್ಯ ಕ್ರಮಗಳನ್ನು ಆದೇಶಿಸಿದೆ. ನೆಕ್ಸ್ಟ್, ಸಂಘದ ಆಡಳಿತಾಧಿಕಾರಿಯು ಆಡಳಿತ ಮಂಡಳಿಯ ಚುನಾವಣೆ ನಡೆಸಲು ಕರ್ನಾಟಕ ಸಹಕಾರಿ ಸಂಘ 1959 ಕಲಂ 28B 2 ಮತ್ತು 3 ಅನ್ವಯ ಕ್ರಮ ಮಾಡಲು ಸೂಚಿಸಿದೆ. ವಾಟ್ ಇಸ್ 28B ಮತ್ತು 2? 28(2) my lord. B2 is the member of the committee who have failed to make arrangement for election. 28B sub 2. The members of the committee who have failed to make arrangements for election within the time limit specified in section 39A shall be deemed to have vacated their office on the last day of time limit so specified, and such members shall not be eligible for election as members of the committee for a period of 5 years from the date of expiry of their term. 28B2 and again 3 my lord. The administrator who shall assume charge under subsection 5 of section 28A shall as early as possible, but within a period of 6 months, arrange for the constitution of new committee of the society in accordance with the Act, rules and bylaws. My resolution submission, my lord. We have passed a resolution. We have recommended in the month of 8/10/2021, well within the time before expiry of that period. Now the administrator was under the entire management was under administrator. Now what is fault with us? Now because we have given a serious charges and complaint against this officer or the Karnataka. Now in the last, when you want to publish this voters list or names, wherein he has said that 28 ಚುನಾವಣೆ ಸೋಲಿಸಲು ಅನರ್ಹರು. Provision invoked is 28B subclass 2.
What is Annex A?
Annex A is earlier 1920 meeting. We have called general body meeting.
Dated 12/10/2020.
12/10/2020. It was the body was in existence. It expires only on 8/10/2021.
You are required to hold elections
on expiry of 8/10 only.
Expiry alla.
On or before 8/10, my lord. On or before 8/10. Meanwhile, the government notification and circulars have also put at annexure C also. It was from time to time, 6 months, they have extended because of COVID. And there also they have mentioned about our recommendation. We have recommended it.
Yes. Okay. The AGA takes notice for response number 1 to 3. Then Council 3, TL Kiran Kumar. He directed to take notice for response number 4. Issue notice to response number 5. Then counsel for the petitioner is directed to serve a copy of the petition on the learned AGA and the 2 sets on learned counsel for response number 4. Next para. The grievance of the petitioners is that they being the directors of the 5th respondent, Takenahalli Milk Producers Cooperative Society Limited, having been elected to the board on,
they were elected in the year 2016, that is 8/10/2016. Date I am not definitely 2016 month. It expires on 8/10/2021.
In the month of October 2019.
16.
were required to hold the elections to the board on or before
8/10/2021.
8/10/2021. Stop. In this regard, the
Annexure C, page 18.
the board took a decision to hold the elections as stipulated in the bylaws and requested for appointment of a returning officer. Full stop. However, due to the restrictions placed by the state government in the matter of holding elections in view of the COVID-19 pandemic, the returning officer was not appointed by the authorities empowered under the Karnataka Cooperative Societies Act, and this is evident from Annexure C dated 21/10/2021. Stop. Annexure C is an order passed by the Assistant Registrar of Cooperative Societies, Division. Although the board of directors had sought for appointment of a returning officer to conduct the elections well within the stipulated time, on account of the COVID-19 pandemic, the returning officer could not be appointed. Full stop. However, administrator was appointed since the term of the board had come to an end. Full stop. The petitioners are aggrieved of the removal of their names from the list of members who are eligible to vote, as could be seen from Annexure F. So, the reason given for their removal from the voters list is that they, being the directors of the fifth respondent cooperative society, failed to conduct elections as required under law. Next para. The fourth respondent, returning officer, is hereby directed to permit the petitioners to participate in the elections, both for voting as well as for contesting to the post of directors of the board, subject to the final outcome of this petition. Yes. Yes. ಏನಮ್ಮ ಪ್ರತಿ ಸರಿ ಹಿಂಗೆ ಆಗುತ್ತೆ ಅದು, ಇಟ್ ವಿಲ್ ಬಿ ಡಿಫಿಕಲ್ಟ್. ಹಾ I will say that even if the AAG doesn't appear on Monday, we'll go on with the matter.
Have it on Tuesday.
Tuesday.
Or any day convenient to the court.
No, it's all
Other
right.
than Monday.
Tuesday is all right.
Because Friday it's cancelled. Too many matters would be coming on Monday.
Tuesday. In spite of several adjournments granted at the request of the learned AGA, a request is once again made. Stop. Therefore, release this matter on 22nd of March 2022. Stop. It is made clear that even if the learned AAG doesn't appear on the next date of hearing, this court will proceed to pass orders after hearing the counsel for the petitioner and the learned AGA.
For his convenience, it can come at 2:30 so that he can adjust his work.
2:30.
He's a busy lawyer.
2:30. Yes. Huh? Learned counsel for the petitioner has filed a memo dated 16/11/2021, seeking leave of this court to dismiss the petition as not pressed. Full stop. The memo is taken on record subject to all just exceptions. Full stop. Next para. Accordingly, the petition stands dismissed as not pressed.
I appear for the petitioners, my lord. I have filed a memo for withdrawal. Petitioners are bill collectors, my lord. They challenged an executive order. Subsequently, now the C&R rules are framed. Draft C&R rules are made. Therefore, they are withdrawing, seeking leave of this court to withdraw the matter, my lord.
The petitioners, along with the learned counsel for petitioners, have filed a memo dated 6/3/2022, seeking leave of this court to withdraw the writ petition. Full stop. The learned counsel for the petitioner submits that the C&R rules are framed.
Draft C&R rules are framed.
The draft C&R rules are framed, and therefore, the grievance of the petitioners is a redressed to certain extent. Stop. Therefore, the instant memo has been filed. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn.
Much obliged.
Annexure A original has not been produced. This is the notice of withdrawal of HRA benefit. So this is the one which has been served on me.
This is addressed only to you.
Yes, yes, ma'am.
But then where is the original then?
Original is with the higher officials. This is only the original which has been served on me in the office hours. So I have given an explanation also that may kindly.
Office has raised an objection regarding production of the original of Annexure A, which is impugned in this petition. Learned counsel for the petitioner submits that what was given to the petitioner is Annexure A. And therefore, he is not in a position to supply the original. Stop. Office objection in this regard is overruled for the time being. Stop. Yes.
My lord, the petitioner is working as a.
The other office objections are overruled.
Ex-defense person appointed as a ASI in the second respondent.
There is no interim prayer.
No interim prayer. No interim prayer.
Learned Central Government Council is directed to take notice for
respondent number R1.
Respondent number 1.
Please.
Then issue notice to response number 2 and 3. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned CG.
IPF for petitioner notes. There are minor objections for us. When verifying affidavit, instead of annexure A to E, it should be A to F for us. I'll comply more.
Yes.
Big stand.
Yes.
Other objections, my lord, is that the certificate copy has not been produced. Lords, I already filed IM for dispensation. And regarding court fee, my lord, it has been paid, my lords. There are 3 objections, my lords. Regarding court fee, I have paid. Second objection is, my lord, in verifying affidavit, my lords, in para 3, it has to do annexure A to E instead of A to F. And another objection is certified copy of annexure B to be furnished.
As regards production of the original or certified copy of the impugned order dated 28/6/2021 at annexure B, the petitioner has filed the IA number 1/2022 seeking dispensation of the same. So, however, the petitioner has undertaken to produce the certificate copy within a period of 4 weeks. So, accordingly, 4 weeks are granted at the request of the learned counsel for petitioner to produce a certificate copy of annexure B. The other office objections are overruled.
This is a matter, the petitioner is working as junior engineer. He was granted increment in the year 2012. That has to be withdrawn while during the retirement process in the year 2021. For respondent number 1 and 2,
same order.
serial number 11.
Srimati MC Nagashri for response number 1 and 2. Srimati Girija Patil for response number 3 to 5. Sir, copies.
Much obliged.
Much obliged.
Yes.
Much obliged.
He has taken steps. Going to take steps, my lord. He has taken the file. I'm sorry, my lord. That is serve the copy and state government is serve it. Lordship on Monday or Tuesday.
At the request of learned counsel for petitioner, release this matter on 22nd of March. Meanwhile, copy of the writ petition shall be served on the learned AGA.
The application may not substitute service paper publication may not. To respond number 3. Kannada Prabha Mangala. Case may not respond number 2 already served. Is remained absent before the court. Respond number 2 is served Mela. Remained absent. Everygu ತಗೊಂಡಿದ್ದೀನಿ paper publications 2 and 3 everygu.
3 ಸರಿ ಆಗಿದೆಯಾ?
3 ಸರ್ವ್ ಆಗಿಲ್ಲ ಸರ್ 2 ಸರ್ವ್ ಆಗಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ 3 ಸರಿ ತಗೊಂಡಿದ್ದೀರಾ ನೋಟಿಸ್? 3 ಸರಿ ತಗೊಂಡಿದ್ದೀರಾ? ಹಾ?
2 ಸರ್ವ್ ಆಗಿದೆ ಸರ್.
ಗೊತ್ತಾಯ್ತು. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಗೆ 3 ಸರಿ ತಗೊಂಡಿದ್ದೀರಾ ನೋಟಿಸ್? ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ಅಂತ?
ಥರ್ಡ್ ಟೈಮ್ ತಗೊಂಡಿದ್ದೀನಿ. For the JRCS and KAT is remained absent respond number 3 madam.
ಸರಿ ತಗೊಂಡಿದ್ದೀರಾ ನೋಟಿಸ್? ಹಾ? ಆಗಿದೆಯಾ? ಮಾಡೋಣ ಎ ನಂಬರ್ 1 of 2022. This application is filed by the petitioner seeking leave of this court to take out paper publication as substituted service in respect of response number 2 and 3. Stop. Then a counsel submits that although response number 2 has been served, the Cooperative Bank remains unrepresented, and therefore, along with the third respondent, notice will also be taken in respect of respondent number 2. Full stop. The learned counsel submits that although 3 times notice was taken out to respondent number 3, and the respondent number 3 is residing in the address stated in the cost title, he has been evading service of notice. Full stop. Next para. Consequently, IA number 1 of 2022 is allowed. The petitioner is permitted to take out paper publication in Kannada Prabha daily newspaper on or before Bangalore edition on or before 31st of March 2022, and the next date of hearing shall be 13th of April 2022. Yes.
Still number 22, I appear for petitioners in this case, my lord. The matter pertaining to my lord, regularization of daily wage employees of the petitioners who have been serving my lord for past more than 30 to 34 years in the municipality, my lord. The government has also filed a reply in this case. Their case has been rejected by the deputy commissioner, my lord, though similarly situated persons have already been regularized by the government, by the deputy commissioners of other district, my lord. The government has already passed an order, my lord, confirming their regularization as water supply helpers, my lord. They are all water supply helpers, group D employees. They have not been regularized, my lord, though they have served for more than 30 to 34 years, my lord. Lord, the director of municipal administration himself had addressed a letter, my lord, to the government, saying that, my lord, these people are working from past more than 32 years, that is Annex ZG. Their cases have to be considered, my lord, for regularization.
Page number?
Page number 192, my lord.
You had approached this court earlier?
No, my lord, we have not approached this court earlier. My lord.
What
Other
is,
persons, my lord,
annex-
similarly.
Annexure U, page
Annexure
number
U, my lord,
119.
Annexure U is, my lord, order passed by, approached by other fellows, my lord. Similarly situated persons, my lord, they were bill collectors, my lord. In fact, they had approached this honorable court, my lord, seeking for regularization. And this honorable court directed the authorities, my lord, to consider their case in the light of the Uma Devi's case, my lord. Pursuant to that, my lord, they have the second respondent herein has passed an order regularizing their services, my lord.
That is annexure V, is it?
The order passed by them is, my lord, that is annexure, my lord, X, my
B,
lord.
page 135.
135 is the order passed it is the order passed by the government, my lord. In the case of similarly situated Group D employees, my lord, their services, my lord, who are regularized by the Deputy Commissioner in the year 2007 or 8. Now, the government has passed an order, my lord, to transferring their services to BBMP. Lord, here, page number 141, Neeru Sarabara Sahayakaru, ellaru idare idaralli. The only thing is that, my lord, though we are working as water supply helpers, Lord, what is the thing is that, my lord, the earlier rules of C&R, rules of municipalities, my lord, they had not provided the posts of water supply helpers, my lord, because these earlier villages, my lord, there was no underground water supply services, my lord, at that time. As and when the requirement, my lord, came, the municipalities, my lord, started recruiting the people, my lord, on daily wage basis to work as a water supply helpers, my lord. That was the situation.
Then the problem is, problem is, if your appointment was not in respect of a sanctioned post,
please, my lord,
you will not be
the same
able
thing,
to get
my
that
lord,
benefit.
the same thing has been considered by the second respondent while regularizing the orders passed by, my lord, this honorable court. Annexure X may kindly be seen.
My lord, 181 kindly, my lord.
Page
181.
One ನಿಮಿಷ.
ಇಲ್ಲಿ annexure X may kindly be seen, my lord.
Page number
153. The relevant page is that, my lord, page number 156, my lord. Rather, my lord, page number 158 may kindly be seen, my lord. Page number 158. My lord, these cases, my lord, which my lords referred that annexure U, pursuant to that order of this honorable court, my lord, these persons came to be regularized. They were all working as bill collectors. My lord, what the court has said, my lord, what the respondent, second respondent has said that, my lord, is, kindly see, my lord, page number 158. May I read, my lord, in the mid of the pair, my lord. ದಿನಾಂಕ 1/1/86 ನಂತರ ನೇಮಕಗೊಂಡ ಪೇಜ್ ನಂಬರ್ 158, my lord. ದಿನಾಂಕ 1/1/86 ನಂತರ ನೇಮಕಗೊಂಡ ದಿನಗೂಲಿ ನೌಕರರುಗಳನ್ನು ಘನ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ತೀರ್ಪಿನನ್ವಯ ಗ್ರೂಪ್ ಸಿ ವೃಂದದ ನೌಕರಗಳ ಸೇವೆ ಸಕ್ರಮಾತಿಗಾಗಿ ದಿನಾಂಕ 25/7/2012 ಆಯುಕ್ತರು ಪೌರಾಡಳಿತ ನಿರ್ದೇಶನಾಲಯ ಇವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ರಾಜ್ಯ ಮಟ್ಟದ ಪರಿಶೀಲನಾ ಸಭೆಯಲ್ಲಿ ಗ್ರೂಪ್ ಡಿ ನೌಕರರ ಸೇವೆಯನ್ನು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆಯವರು ಸಕ್ರಮಗೊಳಿಸಿರುವ ವಿಷಯವನ್ನು ಪ್ರಸ್ತಾಪಿಸಲಾಗಿದ್ದು, ಸದರಿಯವರುಗಳಿಗೆ ಸೇವೆಯನ್ನು ಸಕ್ರಮಗೊಳಿಸಿರುವ ಕ್ರಮವನ್ನು ಸರ್ಕಾರವು ದಿನಾಂಕ 13/5/2011 ಆದೇಶದಲ್ಲಿ ಒಪ್ಪಿರುತ್ತದೆ. That the ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ which I refer to, my lords, just now, my lord. ಅದು ಗವರ್ಮೆಂಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿಕೊಂಡಿದೆ. ಸಿಮಿಲರ್ಲಿ ಸಿಚುಯೇಟೆಡ್ ಪರ್ಸನ್ಸ್ ಅದರಲ್ಲೂ ವಾಟರ್ ಸಪ್ಲೈ ಹೆಲ್ಪರ್ಸ್ ಎಲ್ಲ ಇದ್ದಾರೆ, ಆಯ್ತಾ. ಸೊ ನಂತರ ರಿಟರ್ಜಿದಾರರುಗಳು ಗ್ರೂಪ್ ಸಿ ವೃಂದದ ನೌಕರರುಗಳಾಗಿದ್ದು, ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಸಕ್ರಮಗೊಳಿಸಿರುವ ಸದರಿ ಗ್ರೂಪ್ ಡಿ ನೌಕರರ ಸಮಕಾಲೀನರಾಗಿದ್ದು, ಅವರುಗಳಂತೆ ಇವರು ಸಹ ಸುಮಾರು 15 ವರ್ಷಗಳಿಂದ 20 ವರ್ಷಗಳ ಹೆಚ್ಚು ಕಾಲ ಸೇವೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಹಾಗೂ ಸರ್ಕಾರದ ಆದೇಶ ಗ್ರಾಮ ಸಂಖ್ಯೆ 10/1/1994 ಅನ್ವಯ ಮಂಜೂರಾದ ಖಾಲಿ ಹುದ್ದೆಗಳನ್ನು ಪರಿಗಣಿಸಿ, ಅದು ಪರಿಗಣಿಸ್ತಾ ಇದ್ದಾರೆ ಇವರು. ಇವರ ಸೇವೆಯನ್ನು ಸಕ್ರಮಗೊಳಿಸಲು ಸಮಿತಿಯು ತೀರ್ಮಾನಿಸಿ ಈ ಸಂಬಂಧ ಸರ್ಕಾರದ ಸ್ಪಷ್ಟೀಕರಣ ಅನುಮೋದನೆ ಪಡೆಯುವ ಬಗ್ಗೆ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಲು ತೀರ್ಮಾನಿಸುತ್ತಾರೆ. ರಿಟ್ ಅರ್ಜಿದಾರರು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನ್ಯಾಯಾಲಯದಿಂದ ದಾಖಲಿಸಿರುವುದರಿಂದ ನೌಕರರ ಸೇವಾ ಸಕ್ರಮಾತಿ ಸಂಬಂಧ ರಿಟ್ ಅರ್ಜಿದಾರರು ಮಂಜೂರಾದ ಖಾಲಿ ಹುದ್ದೆಗೆ ನೇಮಕವಾಗದ ಕಾರಣ ಸಭೆಯ ತೀರ್ಮಾನದಂತೆ ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ದಿನಾಂಕ 10/1/94 ಅನ್ವಯ ಮಂಜೂರಾದ ಖಾಲಿ ಹುದ್ದೆಗಳನ್ನು ಪರಿಗಣಿಸಿ. ಯಾಕಂದ್ರೆ ವಾಟ್ ಹ್ಯಾಪನ್ ಮೈ ಲಾರ್ಡ್ ಇನ್ ದಿಸ್ ಕೇಸ್, ಇಲ್ಲಿ ಇವ್ರದೆಲ್ಲ ಏನಾಗಿತ್ತು, ಬಿಲ್ ಕಲೆಕ್ಟರ್ಸ್ ನಲ್ಲಿ they were appointed as bill collectors way back in the year 1991 or 92. At that time there were no rules as that of present situation of the bill petitioners herein. ರೂಲ್ಸ್ ಬಂದಿದ್ದು
Sorry, but if you are similarly situated,
please.
Why your case was not considered?
That is what my problem is. They have not done so. What the Deputy Commissioner has said way back, my lord, in the year 2006 itself, the Deputy Commissioner has specifically said, ಅದೇ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಈಗ ಏನ್ ಮಾಡ್ತಾರೆ, ಇದು ಏನು ಮಾಡಕ್ ಬರಲ್ಲ, ಯಾರು ಎಲಿಜಿಬಲ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 103 ಫಾರ್ ಅ ಮೊಮೆಂಟ್, my lord. 103 ದಯಮಾಡಿ ನೋಡಿ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಇದನ್ನ ಕಾಲಮ್ ಹಾಕಿದೀನಿ ಸ್ವಾಮಿ, ಈ ಪೇಪರ್ಸ್ ನ ಕೆಳಗಡೆ KR ನಗರ HR ಕೇಶವ, ದಟ್ ಈಸ್ ದಿ ಫಸ್ಟ್ ಪಿಟಿಷನರ್ 103 ನಲ್ಲಿ ಸ್ವಾಮಿ. ಕೆಳಗಡೆ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಒಂದ್ ಸಚ್ ಇದು ಏನಂತಂದ್ರೆ ನೇಮಕಾತಿ ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು ಕೊನೆಗೆ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ನೋಡಿ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ ಅಲ್ಲಿ ರೈಟ್ ಸೈಡ್ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಬಲ್ಗಡೆ 1971 ವೃಂದ ನೇಮಕಾತಿ ಪ್ರಕಾರ ನೀರು ಸರಬರಾಜು ಶಾಖೆಯ ಹುದ್ದೆಗಳು ಮಂಜೂರಾತಿ ಆಗಿರುವುದಿಲ್ಲ. ಆದರೆ ಕುಡಿಯುವ ನೀರಿಗೆ ನೀರಿನ ಶಾಖೆಗೆ ಅವಶ್ಯಕತೆ ಇದ್ದು ಇವರ ಸೇವೆ ಸಕ್ರಮಗೊಳಿಸುವ ಬಗ್ಗೆ ಸ್ಪಷ್ಟೀಕರಣ ಕೋರಿದೆ ಅಂತ ಹೇಳ್ಕೊಂಡ್ರು. ಆ ಸ್ಪಷ್ಟೀಕರಣ ಸಿಗದೆ ಇದ್ರೆ ಏನಾಯ್ತು, ಡೆಪ್ಟಿ
your educational qualification is only 8th standard.
ಹೌದು, ಗ್ರೂಪ್ ಡಿ ಎಂಪ್ಲಾಯಿ ಸ್ವಾಮಿ. ಅವ್ರು ಕನ್ನಡ ನಾಲೆಡ್ಜ್ ಇನ್ ಕನ್ನಡ ಇದ್ರು ಸಾಕು, ನಾಲೆಡ್ಜ್ ಇನ್ ಕನ್ನಡ ಅಂತ ಇದ್ರು ಸಾಕು. ಅವಾಗ 71 ರೂಲ್ಸ್ ಅಲ್ಲಿ ಹೆಲ್ಪರ್ಗೆ ಮತ್ತೆ ಅವ್ರಿಗೆಲ್ಲ ನಾಲೆಡ್ಜ್ ಇನ್ ಕನ್ನಡ ಅಂತ ಇದ್ರು ಸಾಕು ಸ್ವಾಮಿ. ರೂಲ್ಸ್ ಇನ್ ಕಾಪಿನಲ್ಲಿ ಅವಾಗಿತ್ತು, ಆ ತರನೇ ಇದ್ದಿದ್ದು.
No, sir. We will ask them to consider us.
Please, my lord. Please, my lord.
We can't say that you are eligible and therefore adalla barodilla. Yes.
Annexure ZD, my lord, one page 181 maybe can you?
181.
ಅದರಲ್ಲಿ ವಾಪಸ್ ಕಳಿಸಿದ್ದಾರೆ.
ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ. ZD
ಅಂತ ಹೇಳ್ತಾರೆ,
ಅದನ್ನೇ ಹೇಳ್ತಾರದು ನಾನು.
181 ಮೈಸೂರು ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳಾದ ಸ್ವೀಕೃತಗೊಂಡ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಜಿಲ್ಲಾ ಮಟ್ಟದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುವ ಡಿ ಗ್ರೂಪ್ ನೌಕರರ ಪೈಕಿ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಷರತ್ತುಗಳನ್ನು ಪೂರೈಸದ ಕಾರಣ ಹಾಗೂ ಸದರಿ ನೌಕರರು ನೇಮಿಸಿಕೊಂಡ ಅವಧಿ ಹುದ್ದೆ ಖಾಲಿ ಇಲ್ಲದ ಕಾರಣ ಸಕ್ರಮಾತಿಗೆ ಅರ್ಹರಾಗಿರುತ್ತಿಲ್ಲ ಎಂದು ಪರಿಗಣಿಸಿ ಉಲ್ಲೇಖನ 2ರ ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಿ ನಿರ್ಣಯ ಕೈಗೊಳ್ಳಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಮೈಸೂರು ಜಿಲ್ಲಾ ವ್ಯಾಪ್ತಿಯ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುವ ಡಿ ಗ್ರೂಪ್ ನೌಕರರು ಸಕ್ರಮಾತಿಗೆ ಅರ್ಹರಾಗಿರುವುದನ್ನು ತಿಳಿಸಲಾಗಿರುತ್ತದೆ.
This letter, endorsement or letter, my lord, is challenged hearing before this court, my lord. Pursuant to this, what I referred annexure ZG, my lord, may kindly be seen. 2019 letter, page number 192. ಅದಕ್ಕೆ ಇಲ್ಲ ಆನ್ಸರ್ ಸ್ವಾಮಿ. 192 is the answer to my learned friend's submission. Relevant page is page number 193, my lord. The director of municipal administration, who is the head of the department for these municipal employees, has himself who is about to deputy commissioner, has himself addressed this letter. May I read, my lord? ಇಲ್ಲಿ 193 ನಲ್ಲಿ ಮಧ್ಯದಿಂದ ನೋಡಿ ಸ್ವಾಮಿ ದಯಮಾಡಿ. ಆದರೆ ಗ್ರೂಪ್ ಸಿ ಹೊಂದದ ನೌಕರರಿಗೆ ಅಂತ ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ, ಆದರೆ ಗ್ರೂಪ್ ಸಿ ವೃಂದದ ನೌಕರರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹಲವು ಪ್ರಕರಣಗಳು ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಉಮಾದೇವಿ ಪ್ರಕರಣ 1ನೇ ಷರತ್ತಿನಂತೆ ಮಂಜೂರಾದ ಖಾಲಿ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಆಗಿರುವುದಿಲ್ಲವೆಂಬ ಕಾರಣಕ್ಕೆ ತಿರಸ್ಕೃತಗೊಂಡಿವೆ. ಅದಕ್ಕೆ ಪ್ರಮುಖ ಕಾರಣಗಳು ಈ ತರಂತ ಇದಾವೆ. ಸ್ಟಾಫಿಂಗ್ ಪ್ಯಾಟರ್ನ್ ನಿಯಮಾವಳಿ 1973 ರಚನೆ ಆಗಿದ್ದು ಸದರಿ ಅವಧಿಯಲ್ಲಿ ಕೈಂಡ್ಲಿ ಸಿ ಮಲ ನೀರು ಸರಬರಾಜು ಶಾಖೆಗೆ ಸಂಬಂಧಿಸಿದ ಹುದ್ದೆಗಳು ಪುರಸಭೆಗೆ ಮಂಜೂರಾಗಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ನೌಕರರ ನೇಮಕಾತಿಯು ಖಾಲಿ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಆಗಿಲ್ಲವೆಂಬ ಪ್ರಸ್ತಾವನೆಗೆ ತಿರಸ್ಕೃತವಾಗಿದೆ. ಇದೇ ಕಾರಣಕ್ಕೆ ನಾನು ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋದು. ಗ್ರೂಪ್ ಸಿ ಹುದ್ದೆಗಳು ಮಂಜೂರಾತಿ ಆದೇಶ ಲಭ್ಯವಾದ ಕಾರಣ ಪ್ರಸ್ತಾವನೆ ತಿರಸ್ಕೃತಗೊಂಡಿರ್ತವೆ. ಆದ್ರೆ in the case of this honorable court, my lord, whereas a direction was given, my lord, by this court, referring to that, this they may address a letter. ಮಾನ್ಯ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ರಿಟರ್ಜಿ ಸಂಖ್ಯೆ 7 ರಲ್ಲಿ ಮೈಸೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ನೌಕರರ ವಿರುದ್ಧ ಸರ್ಕಾರ ಮತ್ತು ಮೈಸೂರು ಮಹಾನಗರ ಪ್ರಕರಣದಲ್ಲಿ 28/2/2012 ನೀಡಿರುವ ಆದೇಶದಲ್ಲಿ ಹುದ್ದೆಯ ಅಗತ್ಯತೆ ಹಾಗೂ ಕೆಲಸದ ಪ್ರಮಾಣ ಇತರೆ ಎಲ್ಲಾ ಅಗತ್ಯತೆಗಳನ್ನು ತೃಪ್ತಿದಾಯಕವಾಗಿ ಪೂರೈಸಿದಲ್ಲಿ ಅರ್ಜಿದಾರರ ಸೇವೆಯನ್ನು ಸಕ್ರಮಗೊಳಿಸಬಹುದೆಂದು ತೀರ್ಮಾನಿಸಿ ಮಂಜೂರಾದ ಖಾಲಿ ಹುದ್ದೆಗೆ ನೇಮಕ ಆಗಿರುತ್ತಲ್ಲವೆಂದು ನೀಡಿದ ಹಿಂಬರಹವನ್ನು ರದ್ದುಪಡಿಸಿರುತ್ತದೆ. ಅದನ್ನ ರೆಫರ್ ಮಾಡಿನೇ ನಾನು ಓದನಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರಿಗೆಲ್ಲ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿದ್ದಾರೆ ಬಿಲ್ ಕಲೆಕ್ಟರ್ಸ್ ಗಳಿಗೆ 64%ಗೆ. ಆನ್ ದಟ್ ಬೇಸಿಸ್ ನಮ್ದು ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಬಹುತೇಕ ಪ್ರಕರಣಗಳಲ್ಲಿ ದಿನಗೂಲಿ ನೌಕರರು ಸುಮಾರು 24ಕ್ಕೂ ಹೆಚ್ಚಿನ ವರ್ಷಗಳ ಸೇವೆ ಸಲ್ಲಿಸುವುದರಿಂದ ಇಲ್ಲಿ 34 ವರ್ಷ ಆಗಿದೆ. ಮಾನವೀಯ ನೆಲೆಯಿಂದ ಸದರಿಯವರು ಮಂಜೂರಾದ ಹುದ್ದೆಯಲ್ಲಿ ಕರ್ತನಿಸುತ್ತಾರೆ ಎಂದು ಪರಿಗಣಿಸಿ ಉಮಾದೇವಿ ಪ್ರಕರಣದ 1ನೇ ಷರತ್ತಾದ ಮಂಜೂರಾದ ಖಾಲಿ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಹೊಂದಿರಬೇಕು ಎಂಬ ಷರತ್ತಿಗೆ ವಿನಾಯಿತಿ ನೀಡಿ ಸೇವೆ ಸಕ್ರಮಾತಿ ಮಾಡಲು ಗಡುವು ವಿಸ್ತರಿಸಿದಲ್ಲಿ ಮಾತ್ರ ಸಕ್ರಮಾತಿ ಪ್ರಸ್ತಾವನೆ ಮರುಪರಿಶೀಲಿಸಲು ಅನುಕೂಲವಾಗುತ್ತದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Government has to take a decision, my lord, because my similarly situated water supply helpers of other municipalities, which I read to my lord, Annexure V, which is a gazette copy, page number 135. Water supply helpers ಬೇರೆ ಮುನ್ಸಿಪಾಲಿಟಿ ಎಲ್ಲ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿ ಗವರ್ಮೆಂಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡು ಗೆಜೆಟ್ ಮಾಡಿಬಿಟ್ಟಿದೆ, BBMP ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದೆ ಅವನ್ನೆಲ್ಲ. ನಾವೇ ಯಾಕೆ ತೊಂದರೆ ಪಡ್ಬೇಕು ಅಂತ ನನ್ನ ಒಂದೇ ಸಬ್ಮಿಷನ್ ಅಷ್ಟೇ.
No, that is Group C, that was all in respect of Group C employees.
ಇಲ್ಲ Group D ಇಲ್ಲಿ ದಯಮಾಡಿ ನೋಡಿ ಸ್ವಾಮಿ, ಪೇಜ್ ನಂಬರ್ 135 ನೋಡಿ ಸ್ವಾಮಿ, 135.
ಪ್ರಸ್ತುತ ಸಿ ವೃಂದದ ನೌಕರರ ಸೇವಾ ಸಕ್ರಮಾತಿ.
ಅಲ್ಲ ಒಂದು ನಿಮಿಷ, ಇಲ್ಲಿ 135 ನೋಡಿ ಸ್ವಾಮಿ, 135 ನಲ್ಲಿ
the communication of the Director of Municipal Administration at Annexure ZG is in respect of Group C employees.
ಅಲ್ಲ ಇಲ್ಲಿ ವಾಟರ್ ಸಪ್ಲೈ ನೀರು ಸರಬರಾಜು ಸ್ಟಾಫಿಂಗ್ ಪ್ಯಾಟರ್ನ್ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ. ಅಲ್ಲಿ ವಾಟರ್ ಸಪ್ಲೈ ನಲ್ಲಿ ಇವ್ರು ಬರಲ್ಲ ಸ್ವಾಮಿ, Group C ಬರಲ್ಲ.
But it is only in respect of Group C employees.
ಸ್ವಾಮಿ ಇಲ್ಲಿ ನೀರು ಸರಬರಾಜು ಶಾಖೆ ಬಗ್ಗೆನೂ ಹೇಳ್ತಾರೆ ಅವರು. ನೀರು ಸರಬರಾಜು ಶಾಖೆ ಅಂತಂದ್ರೆ
ಅದರಲ್ಲೇ
ಹೆಲ್ಪರ್ ವಾಲ್ಮನ್ಗಳು ಬರ್ತಾರೆ ಸ್ವಾಮಿ.
Group C employees ಮಾತ್ರ.
ಇಲ್ಲಿ ಹೆಲ್ಪರ್ ವಾಲ್ಮನ್ಗಳು ಬರ್ತಾರೆ ಸ್ವಾಮಿ ನೀರು ಸರಬರಾಜು ಶಾಖೆ ಅಂತಂದ್ರೆ, ಅದರಲ್ಲಿ Group C ಗಳು ಬರಲ್ಲ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ Group C Group D ಬಗ್ಗೆ ಎರಡೂ ಹೇಳ್ತಾರೆ ಅವರು. And moreover, 135 may kindly be seen, my lord. 135 ಗೆಜೆಟ್ ಕಾಪಿ ದಯಮಾಡಿ ನೋಡಿ ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಏನಾಗಿದೆ, ಉಮಾದೇವ್ ಪ್ರಕರಣ ಬಂದ್ಮೇಲೆ 135 my lord. This is a gazette copy of the Urban Development Department, first respondent. Relevant page is at page number 137. After Uma Devi's case, my lord, Deputy Commissioner of Bangalore District has regularized several municipal employees, my lord, who are working in the municipalities situated around Bangalore city. My lord, that regularization order has been accepted by the government order 13/5/2011, that is Annexure V. Relevant page is page number 137, my lord. May I read, my lord? 137.
Please wait, sir.
Please, ma'am. Please, ma'am.
Where are you people working now?
We are working at the Town Municipal Council, KR Nagara, my lord.
KR Nagara.
KR Nagara, Mysore district, my lord.
Perfect. The petitioners who claim to be working at the Town Municipal Council, KR Nagara, or before this court, KR Nagara, as Group D employees, are before this court, challenging the communication dated 14/11/2016 made by the Deputy Commissioner, Mysore District, to the Chief Officer of the Town Municipal Council, Chief Officers of the Town Municipal Councils of KR Nagara, Bannur, and Piriyapatna, declining to consider the case of the petitioners for regularization of their services in terms of the decision of the Honorable Supreme Court in the case of Secretary, Government of Karnataka versus Uma Devi. Stop. And the petitioners seek directions to the respondent authorities to consider their case for regularization in terms of the earlier decisions of this court in WP number 13555 of 2008 and connected matters dated 11/6/2009 semicolon WP number 35221 of 2011 and connected matters dated 28/2/2012 and government orders dated 13/5/2011 at Annexure V and similar orders at Annexures X and Y dated 22/12/2012 and 29/12/2012. Stop. Next paragraph. Learned counsel for the petitioner submits that the case of the bill collectors who were working in the town municipal councils have been considered favorably by this court in the decisions cited herein above. Stop. Consequent to the directions issued by this court, the state government also passed necessary orders granting the benefit of regularization of their services, and therefore the petitioners are before this court seeking similar benefit. Stop. Learned AGA, however, contends that even as per the impugned communication dated 14/11/2016, it is clear that the Deputy Commissioner has found that the petitioners do not satisfy the requirement as enshrined in paragraph number 53 of Uma Devi's case, and therefore their request for regularization has been rejected. So, next paragraph. The learned AGA submits that it is evident from the material placed on record that the petitioners, even if appointed, as daily wage workers, the appointment was not against sanctioned posts, and the petitioners do not possess the requisite educational qualification and the other criteria as mandated by the Honorable Supreme Court in the case of Uma Devi. Stop. Next one. Having heard the learned counsel for the petitioners and the learned AGA, and on perusing the petition papers, this court finds that a general order rejecting the case of all the petitioners cannot be sustained. So, application of mind is required to be done in respect of each and every petitioner. To point out as to whether which of the criteria is lacking in each of the case. A general order simply stating that the petitioners do not possess the requisite qualification, cannot be sustained. Stop. Consequently, the
next is ZD, my lord.
respondent authorities, including the Deputy Commissioner, Mysore District, and the state government, Department of Urban Development, are hereby directed to reconsider the case of each of the petitioners for regularization of their services in terms of para 53 of the decision of the Honorable Supreme Court in the case of Uma Devi. Stop. Due consideration has to be given in respect of each and every petitioner to find out whether they possess all the requisite qualification and they fulfill all the criteria as required in terms of the directions issued by the Honorable Supreme Court. Stop. Necessary orders shall be passed after consideration of the case of each of the petitioners, and necessary orders shall be passed as expeditiously as possible and at any rate within a period of 3 months from the date of receipt of a certified copy of this order. Serial number? Similar orders, as in serial number 10. Yes. Yes.
We have done. Illness will be taken on 22nd.
For all the occasions, this is 6th bench, I request humble request.
Finally.
No, humble request,
because on all the occasions, whenever the decisions comes, they are taking for 1 year to give another reason. Morning was a first or Madhyam year, again they're taking time.
What is the matter about?
Sixth time.
What is the matter about?
Number 5 working as a waterman since 1992. Thereafter completed service, but is there one of the petitioner is currently annexure G, page part 1.
Respondent number 5 is working as
Waterman.
I
am eligible. I worked more than 20 years. I am eligible for bill collector. Whereas currently annexure G, page part 1. The petitioner is one of the elected member of the panchayat. Thereafter become Upadhyaksha. And they will get created fixation document with other members. So they appointed as a bill collector. That order is husband number 3 or 4 and already they passed the order. Next year, G page 41.
You are for the
R5.
You are for respondent number 5.
Please,
there is an order of stay, na?
Stay already expired. Stay. I'm not impressed with the stay.
No, you are appearing for respondent number 5.
Please, stay already stay ಆಗಿತ್ತು. Stay already 1 year time bonding. There are
you are continuing to serve.
Not at me. Still I am working as a waterman only.
What is the challenge raised?
Next year G, next year G. Page 41. May I read?
You went before the authority.
Please, page 41 minutes. Para number 2. See, DM Munchikaya, Munchikaya, where the Gram Panchayat, that's why that's what this Gram Panchayat, I carry that. Nantara, the Gram Panchayat, but the Shibukan with that. Page number 41. Next year G. Para 2. Then DM Munchikaya, Munchikaya, Erindapanelli Gram Panchayat, advisor in the Hatasari, Gram Panchayat, I carry that. Nantara, Erindapan Gram Panchayat, Upadhyaksha, Kathir. Number 3. Erindapan Gram Panchayat, Kathir, bill correct to Mumbartravada with the gay, 21 Pazika Prakadon receipt and 28 Gram Panchayat, Religente, Munchikaya, Munchikaya Muran, the previous line with the Madhya. Adare, Adiran Kushkar, the created documents. Thereafter, I will Paisula Panchayat Karagrazilla. That's the Kario, Kaiser Secretary, that is a duplicated document, fixture documents. Kindly selection that we have 4 minutes. Our Ram Panchayat, Munjachkan, bill collector has come at bill collector, Jaus,
ಎಲ್ಲವೂ ಕೊಟ್ಟಿ ದಾಖಲೆಗಳಾಗಿರ್ತವೆ.
It is the last 45 page 45. ಆದೇಶ ಪ್ರಸ್ತಾವನೆಯ ವಿವರಿಸಿದ ಅಂಶಗಳಿದ್ದರೆಯಲ್ಲಿ ವಾದಿಯ ಕೃತ್ಯವಾದ ಹೇಳಿಕೆ ತಿಳಿಸಲಾಗಿದ್ದು ಉಲ್ಲೇಖ 1, 2 ಮತ್ತು 3ರಲ್ಲಿ ನೀಡಿದ ಮಾರ್ಗಸೂಚಿಗಳನ್ನು ಪರಿಗಣಿಸದೆ ಮುಂಚಿತವಾಗಿ 2 ಗ್ರಾಮ ಪಂಚಾಯತ್ ನಿರ್ಣಯ 22/7 ಕ್ರಮಸಂಖ್ಯೆ 4ರಂತೆ ಬಿಲ್ ಕಲೆಕ್ಟರ್ ಹುದ್ದೆಗೆ ನೇಮಕ ಮಾಡಿಕೊಳ್ಳುವುದು ನಿಯಮ ಬಾಹಿರವಾಗಿರುತ್ತದೆ. ಮತ್ತು ಸರ್ಕಾರ ಉಲ್ಲೇಖ 3ರ ಆದೇಶ 10/9/2014ರಂತೆ ಲೋಕೇಶ್ ಅವರು ಬಿಲ್ ಕಲೆಕ್ಟರ್ ಹುದ್ದೆಗೆ ಅರ್ಹರಾಗಿರುತ್ತಾರೆ.
ಅರ್ಹರಿದ್ದಲ್ಲಿ ಸದರಿಯವರನ್ನು ಮುಂಬಡ್ತಿಗೆ ಪರಿಗಣಿಸಲು ಆದೇಶಿಸಿದೆ. This order has been challenged.
ಅವರು ಮಾಡೋದು ನಂದು
this order has been challenged by him. There is no
waterman's 1992. There is a government order notification that the waterman working continuously for 5 years is entitled eligible for a bill collector.
All right. A submission is made on behalf of the learned counsel for the petitioner seeking short accommodation. Stop. Learned counsel for the contesting respondent number 5 submits that it's evident as per the impugned order that the petitioner has created fake documents by virtue of which the petitioner contends that he has been appointed as bill collector. Bill collector. So, having found that the document submitted by the petitioner is fake, comma, he has been removed from service. So, moreover, the petitioner was elected as member of the Gram Panchayat and has also served as the vice president of the Gram Panchayat. Stop. Espera. Released this matter on 23rd of March 2022. 22nd. ಒಂದು ದಿವಸದಲ್ಲಿ ಏನೋ ಆಗ್ಬಿಡೋದಿಲ್ಲ. Monday there will be lot of matters because tomorrow a holiday is declared. 23rd. 23rd of March 2022. Stop. No further adjournments will be granted. Yes. Yes. Yes.
Place of auction, my lords.
Yes.
Submission is this, my lords.
Ah.
At the time of submitting, petitioner submitted the representation on 27/5/2019. At that time, he has not objected for the place of.
No question of objecting, sir. It's a statutory provision. It's a statutory provision. No question of him objecting. Okay.
Insofar as solicitation is concerned, I am relying on judgment, my lords. Solicitation, payment of solicitation.
Allah, adalla ಏನು ಬರೋದಿಲ್ಲ.
My lords.
We will only set aside the order, and whatever has to be given to the person who has contested in the auction and successful bidder, he will recover it from the bank.
My lord, as far as this judgment, my lord, person who challenged the auction settlements, he has to.
That question will arise only when he contests the matter. It is not necessary here at this stage.
Kindly appreciate, my lord. Pass.
Sorry.
Para 6, sir. Last page. 8 line down. Setting
last page.
For setting aside sale, as he is entitled to receive 5% solatium on the sale price, he has paid in the event of the sale being set aside. In fact, it is one of the condition precedent that person seeking setting aside of the sale should deposit in addition to the decretal amount the solatium as well at the time of making the application. Here, the judgment debtor has challenged the auction.
They have deposited more than what was awarded. So you consider it at the stage of
that observation may be.
Yes. ಅವರಲ್ಲಿ ಬರಲಿಲ್ಲ. All right. The petitioners are before this court. assailing the order dated 5/9/2019 in execution case number 185 of 2018-19, which arose in dispute number 40 of 2018-19, on the file of the Assistant Registrar of Cooperative Societies and Recovery Officer, Mangalore Subdivision. And the consequential sale proclamation dated 10/6/2019. Stop. Next para. There is no dispute to the fact that the petitioners had borrowed a sum of rupees 25 lakhs from the second respondent, Bhagavati Cooperative Bank Limited, on failure of the petitioner to pay the monthly EMI, recovery proceedings were initiated against the petitioners. Stop. An award was passed by the Assistant Registrar of Cooperative Societies and Recovery Officer. And thereafter, in the execution proceedings, the property mortgaged by the petitioners was brought for auction. Stop. The auction was held on 22/7/2019, and the third respondent was declared as the successful bidder for a sum of rupees 81,20,000. Stop. Next paragraph. Learned counsel for the petitioner submits that the sale confirmation was made on 5/9/2019, and this writ petition was filed on 9/9/2019. Stop. Your Honor, counsel submits that as per the oral directions issued by this court, the petitioner furnished a demand draft in the name of the Registrar General of this court for a sum of rupees 11 lakhs drawn on Karnataka Bank, and this court, by order dated by an interim order dated 29/2019, directed the registry to encash the demand draft and keep the same in fixed deposit. So it was also made clear that the successful party would be entitled to withdraw the amount along with accrued interest. Stop. The submission of the learned counsel for petitioner was also recorded to the effect that the balance amount as indicated in the sale proclamation along 5% of the purchase money to be deposited by the petitioners on or before 27/9/2019. So
This line again,
stay of all further proceedings were directed according. So huh?
Article 26(9). Another 7 lakhs videos. Maybe 1 or 2 days date. That's it.
That's all right. Ultimately,
yes. Totally, my lord, 25 lakhs 61,400. I is the memo.
Okay. Thereafter, starting from 26/9/2019 to 18/11/2019, the petitioner has deposited in all a sum of rupees 25,61,400 before this court, and as per the directions of this court, the same has been kept in fixed deposit to earn interest, which would be which would accrue to the benefit of the successful party. So, next para. On the merits of the matter, the learned counsel for petitioner submits that the respondent authorities and the respondent bank has not followed the requirement of law in the matter of issuance of notice and holding the auction in terms of the requirement of law. So, more particularly, attention of this court is drawn to Rule 38(2)(G of the Karnataka Cooperative Societies Rules, 1960, which mandates that the auction is required to be conducted where the property is situated or such adjoining prominent place of public resort and the same has to be intimated in the auction notice. Stop. Learned counsel further submits that admittedly, in the present case, there is violation of the requirement of Rule 38(2)(g), since the auction has been held in the office premises of the respondent banks at its head office. Stop. Next para. Although learned counsel for the respondent bank seeks to justify the action of the recovery officer in holding the auction at the head office, while stating that the head office is also situated very near to the scheduled property, the submission is not made with full conviction and is not appealing to this court. Stop. The scheduled property bearing survey number 70/4 is situated at Kannabettu, Kadri village of Mangalore Taluk, and whereas the head office of the second respondent, Cooperative Bank, is situated at
Morgan's Gate.
Huh?
Morgan's Gate.
Jepu, Morgan's Gate.
3 kilometers away from the.
Huh?
3 kilometers away from the Judicial property. 8 kilometers.
ಅಲ್ಲ ಇದೇನು ಮಂಗಳೂರು ಸಿಟಿ ನಾ ಇದು
ಸಿಟಿ
ಮ್ಯಾಂಗ್ಳೂರ್ ಸಿಟಿ. ಸ್ಟಾಪ್. Moreover, the petitioners have deposited a sum of rupees 25,61,400 before this court, while
proclamation amount demanded is only
the award amount is rupees
1,92,942.
Where do you get that?
Seal proclamation, it is there. Seal publication, annexure R1.
R1.
Annexure R1 what? Yes, statement of publication. Paper publication. The statement of objections, my lord.
By statement of objection.
R1.
Yes.
R2, my lord.
R2.
Bottom, my lord, there, right side. Mangaluru Taluk Katriga. Degree motta. Bottom, my lord, right side. Degree motta 21,92,940.
R2 is the paper publication.
Paper publication ಇದೆ ಅದರಲ್ಲಿ ಬಾಟಮ್ ಅಲ್ಲಿ ಕೆಳಗಡೆ.
I'm producing original copy of the paper.
Rupees 21,92,942.
Along with interest and expenses.
Really, you will not produce the copy of the award, is it?
Copy of the award is not produced.
Huh?
Not.
ನಿಮ್ಮ ಹತ್ರನೂ ಇಲ್ವಾ? Along with what interest?
But actually, annexure, annexure B, it is there, my lord. This amount is mentioned even in annexure B. Kindly, my lord, page 16. 21,92,942. Page 16. Right side. Bhagavati Sahakara Bank Limited.
ಅದೇ ಬಡ್ಡಿ ಎಷ್ಟು?
ಬಡ್ಡಿ ಎಲ್ಲ ಸೇರಿಸಿದೆ. As on that day, my lord, they will include it. The formality. As on the date of the sale,
My lords, I'm producing award, my lords.
ಕೊಡಿ. Award notice ಅಲ್ಲ. Award. Original award.
However, the petitioner have deposited a sum of rupees 25,16,400 before this court, while the award amount is 21,92,942.
While the amount claimed by the bank was in a sum of rupees 20,30,389, along with interest of rupees 1,61,603 and expenses of rupees 950. Stop. The award declared by the competent authority is in a sum of rupees 21,92,942. Along with the 15% interest till the date of recovery. The petitioners have therefore demonstrated by depositing a sum of rupees 25,61,400 within a period of 3 months from the date of filing of this writ petition. That there was no willful default. Stop. Next para. Provision is also made in Rule 38 of the Karnataka Cooperative Societies Rules, 1960. That even after the expiration of the 30 days period from the date of sale, to enable the borrower to make an application, and the recovery officer is empowered to set aside the sale after recording his reasons in writing. Stop. The proviso to sub-rule 6 bracket A of Rule 38 makes this provision. Stop. Moreover, it is by now well settled that every opportunity is required to be given to the borrower to save his immovable property. Stop. At the same time, the predicament of the auction purchaser who has invested money and deposited the entire sale amount with the recovery officer also should be kept in mind. Stop. Provision is made even under the rules for payment of %5 of the purchase money. Along with interest. Stop. Huh?
This is only to the bank, not to the purchaser. Purchaser solution only. For you. Payment to the purchaser is equal to 5. That doesn't arise in 5% of the purchase money. And for payment to the decree holder, the amount of arrears specified in the proclamation of sale.
Are you relying upon any decision? Did you? ಅದೇ ಇವಾಗ ಇವ್ರು ಕೊಟ್ಟಿದ್ದು ನೀವು ಕೊಟ್ಟಿದ್ದು ಅವ್ರು ಕೊಟ್ಟಿದ್ರು ಅದು. ಹಾ ಹಾ
Generally, civil procedure. There, other parties will also
No,
not.
it's perimeter area. The provisions are perimeter area.
Perimeter.
Yes, yes.
Almost. Under the corporate societies rules, it is only around 5%. Only under rule 5(4).
Sir, this decision is also on the same provisions. Cooperative society is there.
Observations, my lord, here Leonard Judge refers to order 21 rule 92 para 6. And mainly proceeded on the basis. In fact, the subsequent division bench ruling is a 1983 decision of the Leonard single judge. Division bench ruling, which I have given much later, which was affirmed by the Supreme Court also. But no solution has been awarded. And under the rules, it is only under rule 5. Solution is provided. These are Lordship sees the rules and write 4 and 5. There are 2 categories.
Yes.
But under rule 4, solution is provided. Which my learned friend says, cooperative society rules 4A. Immovable property has been sold. Any person either owning such property or holding an interest therein by virtue of a title acquired before such sale may apply to have the sale set aside on his depositing with the recovery officer for payment to the purchaser is sum equal to 5% of the purchase money, and for payment to the decree holder the amount of arrears specified in the proclamation of sale, as that for the recovery of which the sale was ordered, together with the interest thereon and the expenses of attachment, if any, and the sale and other costs. So this is for the bank.
So for 5% is for the
auction purchase. Auction. That's what I said. He is not entitled. Solatium 5%. 4A. And if it is under rule 5, no solution is provided under rule 5.
That is, if you do it within 30 days.
That is within 30 days before the
Correct.
recovery officer itself. Here, my lord, since it is, my lord, because of the mistake of the in such cases. There you see, my lord, they might have followed meticulously the procedure. Still, my lord, last window is given, as your lordship has very rightly observed, my lord, for the judgment debtor to preserve his.
Correct. Adre, you are required to pay 5% of the purchase money.
That's right. If it is under rule 4, you have paid rule 4. This is
81 lakhs 20,000 5%.
Yes, sir. Allah, that is before the recovery officer, if he is set aside, if they have done it correct.
Sir, it's the same thing. Even if it is an order passed by the recovery officer or an order passed by this court, ultimately it is the same thing. You are liable to pay 5%.
What I am saying.
Because otherwise, the interest of the auction purchase, no one will come forward to participate in auction then. To protect the interest of the auction purchaser, these clauses are put.
There is a mistake, my lord, that can be ordered by this court. There is
Yes.
Murder.
No.
Bank should bear it.
No. It is very clear. It is the purchaser.
Allah, that is under rule 48 is very clear.
Correct.
Under rule 5, it is not provided at all.
The mistake, Allah. You are only getting the benefit because they didn't follow the rules. At any rate, see, if you had paid the entire money before the 30 days, all this problem would not have arisen. In this regard, although a decision of this court in the case of Ramesh H versus on the sale price, in sub-rule 4 capital A of rule 38, it is clear that the 5% of the purchase money is required to be borne by the borrower, when the sale is set aside. Stop. It does not matter whether the sale is set aside by the recovery officer himself under the provisions or by an order of this court. Full stop. Nevertheless, it is clear that the petitioner herein is required to pay a sum equal to 5% of the purchase money to the auction purchaser, and pay the decree holder, that is the respondent bank herein, the amount of arrears specified in the proclamation of sale along with interest thereon and the expenses of attachment and other costs due in respect of such amount comma, less the amount which may have been already which may have already been paid by the petitioner. Full stop. Next para. Consequently, this court proceeds to pass the following order. 1. The repetition is allowed in part. 2. The impugned confirmation of sale made in favor of yaru neevu third respondent is hereby quashed and set aside. Stop. Next one. The respondent bank is entitled for the award amount along with interest as noticed herein above. Stop. The third respondent, auction purchaser, is entitled for 5% of the auction amount deposited by the third respondent before the recovery officer, and the petitioner is liable to pay the same to the auction purchaser. Full stop. Next, the respondent bank shall return the entire auction amount deposited by the third respondent back to the third respondent, along with 5% of the said amount to be recovered from the petitioner. Full stop. Next, the Registrar General is hereby directed, Registrar General of this court is hereby directed to
transfer the entire amount. Refund.
to return the entire amount of rupees 25,61,400 deposited by the petitioner, and
I'm permitted to withdraw
with accrued interest.
along with accrued interest to the second respondent bank. Full stop. On receipt of the entire amount, comma, the second respondent bank shall calculate the interest that is accrued to the second respondent bank along with the award amount and retain the same in full and final satisfaction. The rest of the amount, from the rest of the amount, the second respondent bank shall deduct 5% of the auction amount which is required to be returned to the third respondent auction purchaser Full stop. If the same is found short, comma, the petitioner shall be called upon to pay the same on intimation by the second respondent bank, comma, within a period of 2 weeks from the date of intimation.
4 weeks. 4 weeks.
Aden jasti iralla. I don't think it would be necessary also.
Still, my lord, by the abundant cost.
Huh?
Still abundant cost.
4 weeks. ಅಲ್ಲ ಆಗ್ಲಿ
ಅದೆಲ್ಲ ಅವರಿಂದಲೇ ಡಿಡಕ್ಟ್ ಮಾಡ್ತಾರೆ
ಅಷ್ಟೇ. That is why I am saying I don't think
still, my lord, 4 weeks.
4 weeks.
ಒಂದು ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ರಿ, ಇಂಟ್ರೆಸ್ಟ್ ಅಪ್ ಟು ದ ಡೇಟ್ ಆಫ್ ಸೇಲ್, ಅದರ್ವೈಸ್ ದೇ ವಿಲ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಅಪ್ ಟು ದಿಸ್ ಡೇಟ್. Till the date of the sale of the property, society is entitled to bank. No. Very well, very well. Instead of that, that is hardly about 2-3 months. Your lordship kindly say, my lord, till the date of sale only they are entitled to calculate and add the naturally.
No, see, but even the directions,
loan amount, not
even the directions issued by this court, the interim order is that it should go to whoever is successful. If petitioner is successful, actually it has to be returned to him.
That's right. It's interest.
Alva. No, that is the direction given here.
Actually,
adana correct ಮಾಡ್ತೀನಿ. I'll correct that one.
Very well.
That, from the date of the award,
yes,
till the date of deposit, till the date when you deposited the amount before this court.
Instead of that, date of deposit, around since 2-3 days, dates I have deposited. If your lordship says till the date of auction, that till the date of auction. That
no, we will say till the date of filing of this petition.
Very well, very well. Till the date of filing of this.
ಅದನ್ನ correct ಮಾಡ್ತೀನಿ. Yes, ordered accordingly. ಆಗಲ್ಲ ಹಂಗಲ್ಲ ಆಗೋದಿಲ್ಲ ಸರ್. ನೋ ಸರ್, let it come up on Monday. Court officer. 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 Sir, court officer. Sir, court officer, sir. Sabre, court officer Sabre. Sir. Court officer, sir. Court officer, sir.
Court officer, madam. Court officer.
Court officer? Court officer?
Malets, I appear for the respondent number 5 in this matter, please.
Huh? Notice was sent. All right. Any objection?
No objections, Malets. Malets, my only request is, Malets, if a date may be please be fixed. Because there's an order of the Honorable Supreme Court, Malets, for early disposal of this matter.
Order on IA number 1 of 2020. This application is filed. Bring the legal representatives of deceased petitioner number 5 on record. This petitioner died on 10/3/2021. Delay ಎಲ್ಲ ಏನು ಹೇಳಿಲ್ವಾ?
There is a delay, Malets.
End
of February, which is 22, all cases.
Although there is a delay, Learned Counsel for the petitioner submits that in view of the general directions issued by the Honorable Supreme Court in the matter of period, extension of the period of limitation, no application is filed seeking condonation of delay. Full stop. Nevertheless, there is no objection from the respondent to allow the application. Full stop. Consequently, IA number 1 of 2022 is allowed. By permitting the legal representative of the fifth respondent, namely his wife, Srimati Pushpa, to come on record as legal representative of petitioner number 5. Stop. Learned Counsel for the petitioner shall carry out the amendment in the past title and furnish an amended past title within a period of 1 week from today. This has to be heard, is it? Finally.
Please, Malets.
Is this matter for final hearing?
Malets, my only request is if this can come up in B group, please, Malets. There's some
B group will come later in my list. So you choose.
Malets, rule is not issued, please.
B group matters will come later in my list. Final hearing matters will come earlier.
Very well, Malets.
This matter for final hearing on 31st of March. 31st of March.
Grateful.
1st of April. 1st of April.
Grateful.
2:30 matter again, right? ಇವ್ರದ್ದು ರಾಜಗೋಪಾಲ್ ಮತ್ತೆ ರಾಮದಾಸ್ ಅವ್ರ ಮ್ಯಾಟ್ರ್. ರಾಜಗೋಪಾಲ್ ಮತ್ತೆ ಇದು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ Tell the matter. Serial number. Huh? 20? All right. If you want to be listed on Monday, it will be listed. Tuesday. At the request of learned counsel for the respondent, release this matter on 22nd of March. Yes. Yes. Hello, disposal for what? There are parted matters. The learned senior counsels are waiting. No, there's no one appearing for the school. Who are the contesting respondents? Government only. Release this matter on 24th of March. Please start.
I am not able to hear.
Is there? Yes. Before we proceed, the respondent is a university, deemed university. What is this?
Autonomous college.
Unaided institution. I have read both those judgments. I have read both those judgments. Nandanri, ನಾನು ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ. ನಾನು ಬೆಳಿಗ್ಗೆ ಕಳಿಸ್ತೀನಿ. ಎಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ರು? Sir, I have gone through both these judgments. Please see the decision of Jagdish Prasad Sharma. If you have it, it's a 2013 judgment. That's why I was mentioning last time. There is a judgment of the Supreme Court on the very same question. That is Jagdish Prasad Sharma. The angle from which this was required to be noticed is Article 309 of the Constitution. That has not been dealt with by both the judgments. When this question came as to whether the regularization, the regulations of the UGC directing enhancement of the age of superannuation from 60 to 65, this very same question came for consideration before the Honorable Supreme Court. It very clearly stated that insofar as the state government is concerned, the power of providing for service conditions is vested only with the state government in terms of Article 309 of the Constitution. This aspect of the matter has not been considered in both those judgments.
It has been considered, my lords, in Justice
mention madidare, but not
because 309 is not applicable in this particular case. If my lords would like to address on that aspect,
yes,
my lords may fix a date. I will come and argue.
No. Yeah, you please, if you have the judgment with you,
I have that para 78.
It
went by UGC regulations.
Correct.
Here, kindly see judgments of 4 different high court division bench judgments I have placed on record.
Angala, sir. The observation is that in view of the mandate provided under Article 309.
Article 309 would not arise here because mine is a private unaided education institution.
Correct. All of them are affiliated to the state university, the Vishwesvaraya Technological University, which is
exactly, my lords,
which is a university of the state.
My lords, that is exactly what is considered in Pramod's case. In Pramod's case, Supreme Court went by UGC Act, UGC regulations, and then took a view. That
sir, if they have noticed, the decision of the other Supreme Court judgment in Jagjeet Prasad case, that in the context of the mandate provided under Article 309,
the UGC Act has been considered.
Whether the regulations of the UGC or the AICTE
would
be ipso facto applicable to the state government and all the institutions functioning under the state government.
It is not functioning under the state government. Kindly have a look at judgment of the Supreme Court in Pramod, which consider the AICTE Act and its implications, and then Article 254. Article 254 also came up because they went by, my lords, Constitution, entry 66 of list 1.
Yes.
Entry 66 of list 1. My lords, this is a 2016 judgment, Pramod.
Yes.
Pramod is 2016 judgment.
Yes.
And it considers the AICTE Act. And after considering the AICTE Act, it also considered, my lords, para 5 at page 508, that is internal page 4 of my compilation. It considered the All India Council of Technical Education for Brevity issued a notification framing the AICTE pay scale, service conditions, qualifications, regulations. The writ petition was disposed on 27/5. Thereafter, my lords, at para 7,
yes,
the
High Court Division Bench had accepted the state government's contention that state rules will prevail. The Division Bench of the High Court has held in favor of the appellant that as per earlier full bench, the provisions of MEPS Act and MEPS are applicable to employees working in polytechnic, etc., etc. In fact, in that view of the matter, in the earlier round, the appellant was relegated to avail the statutory remedy of appeal before the school tribunal. The division bench noticed the qualification prescribed for the post of principal. However, the division bench accepted the stand of the respondent state that in view of the recommendations made by AICTE made through letter, state government has passed a resolution accepting those recommendations. Then it deals with the qualifications. Then, my lords, para 15. On the issue of age of superannuation, there was no occasion for the High Court to consider the relevant rules or notifications before us. There is a serious controversy as to whether the age of superannuation on the post of a teacher other than principal ought to be 60, 62 or 65. According to the respondent, state government had issued a notification through the Higher Education Department dated 5/3/2000 whereby the age of superannuation for non-government polytechnic institutions has been increased from 58 to 60 years and it can be extended up to 62 years only after obtaining the prior approval of the state government. Similarly, for the post of principal, age of superannuation has been increased to 65 years, but with the rider that the state government should grant approval for further extension of beyond 62 years. On the other hand, the stand of the appellant is that he has been arbitrarily ignored and not considered for extension because of pending litigation against the management of the respondent society since several years. It is the further case of the appellant that state government has never differed with the recommendation of AICTE on the issue of age of superannuation in exercise of the statutory powers under subsection 1 of section 23, read with section 10(1) and 5 of the All India Council of Technical Education. AICTE has issued the regulations dated 5/3/2010 and the regulations inter alia provide for age of superannuation. And since they apply to technical institutions conducting technical education and such other courses for programs and areas as notified to the council from time to time, the age of superannuation for teachers of the polytechnic stand enhanced to 65 years with the sole exception of librarian whose age of superannuation continues to be 62 years. From the materials and rival contentions noted above, it is evident that even as a teacher, the appellant's age of superannuation could have been considered for extended 60 years if steps had been taken for the same in due course. Moreover, the regulations of AICTE being statutory, unless these have been superseded or annulled by a competent authority, the appellant's age of superannuation stood extended up to 65 years. Lastly, and in any event, this court had directed the maintenance of status quo in respect to the appellant service, and such order has been brought by the respondents concerned proceeding to superannuated. Yet another dimension requires special consideration. As per the statutory MEPS rules, appellant should have been promoted, etc., etc. Then, my lords, it is said the AICTE 65 years.
The problem is that Article 309 has not been considered in this case.
Article 309, my lords, will not apply here because it is not a state organization. Article 309.
All these
no,
are
Article 309 will not apply. Kindly take the Constitution itself.
Constitution.
Thereafter, how it has been interpreted by different division benches of at least 3 high courts, I will point out. Now, my lords, services under the state come under part 14.
We'll read Article 309, sir.
Recruitment and conditions of service of persons serving the union or a state.
Yes.
Not any private body, because private bodies become state only for purpose of
all the institutions before the Honorable Supreme Court in that case also were the institutions functioning under the various universities of the state government.
Universities of the state is different from A college affiliated to a university. Because university is a statutory body.
Yes.
State government colleges get affiliated to the university, but they remain employees of the state government. Their Article 309 would apply. A private educational institution affiliated to a university is bound only by the conditions of affiliation. For them, Article 309 will not apply. For example, my lords, suppose a private educational institution teacher is dismissed. My lords would not apply Article 311 to him because he is not an employee of the state falling under Part 14 of the Constitution. He will still remain.
Are they not bound in the matter of fixation of service conditions?
They are not bound. They are not bound because university cannot fix their service conditions. For example, kindly my lords,
yes,
the private educational institutions service conditions are fixed by the state if it is permissible under the Karnataka Education Act. No rule has been made by the state to govern the service conditions of teachers in engineering institutions. Because, for example, first grade colleges they have made, PUC they have made, but insofar as professional colleges are concerned, no rule has been made by the state government under under the Education Act. They do not come under Part 14 of the Constitution because they are not state government employees. That is the reason, my lords, Lordship Justice Nagaprasanna's judgment, Jagdish Prasad has been considered, and it is said these are not state government employees. Now, my lords, the question is, the UGC makes, suppose not CICT makes a regulation and makes it a condition of approval. Suppose my lords, even for a private educational institution, private engineering college is a private educational institution. However, Education Act would not apply to the extent the matters are governed by the AICTE Act. Now, under the AICTE Act, AICTE regulations are made, and it is compulsory for every engineering college to obtain approval of the AICTE. AICTE approval is granted subject to conditions 1, 2, 3, 4, 5. One of the conditions is that you should follow these AICTE regulations 2019 or 2010 as amended from time to time. Therefore, it becomes a condition of approval, not a determination of service condition. That is the reason, my lords, the Part 14 is not applicable. Article 309 is not applicable. There are any number of judgments which say that for university employees even, Article 311 will not apply. That is, my lords, that first judgment in that is the Vijay Narayan Vajpayee versus UP State Fire Health Corporation, where Lordship Justice Chinnapreddy, speaking for the bench, said that a public organization like UP Warehousing Corporation, it is no doubt an instrumentality of state under Article 12, but services under it, this does not become service under the state for the purpose of Part 14 of the Constitution. Nonetheless, though they are not governed by Article 309, 310 and 311, they are governed by Article 14 and 16 because of their being instrumentality of state. Therefore, my lords, the question of who is competent to make the rule, whether it is central government, state government, that would not apply. Here, what I am seeking to enforce is the pure and simple AICTE regulations, which is made a part of the approval condition. If they say that they are under no obligation to follow the AICTE regulations because it is not a condition of approval, that is different. But it is functioning because of approval granted by the AICTE. Difference between the UGC and the AICTE regulation says AICTE regulations has made it mandatory to be followed.
Sir, even the UGC regulations are held to be mandatory.
No, UGC regulations.
Even in Jagdish Prasad Sarma's case, the Supreme Court has held the regulations are mandatory. However, in view of Article 309, in respect of
Article 309 does not come here.
So therefore, if that matter has been dealt with in these two judgments, you can point out for me to say no, this matter has to be sent before the division bench.
Yes, Lord.
You may point out, and say that for these reasons, this matter need not be sent to the division bench. There are various grounds which have not been considered in those two judgments, and I will proceed to hear you. There is no need for me to send it before the division bench.
I will, my lord, all the time seeking is
the
this.
Only thing is you will have to make out a case as to how it can be distinguished from the reasoning given. Yes.
I'll point out, my lord, I 4 propositions of law I will place before my lords.
Yes.
One is Part 14 of the Constitution does not apply to anyone except who is directly employed by the state government or the central government. Rest all instrumentalities of state come in jurisdiction because of Part 3, for whom application is only Article 14 and 16. Here, I am representing an employee of an unaided college, which cannot even be brought under Article 14 and 16, insofar as service conditions are concerned. What I am seeking to enforce in a writ petition here is the statutory service conditions prescribed by the AICTE by its regulation. And my submission before my lord says it is required to be followed by the private engineering colleges because it is a condition of approval. That is how my lords, division benches of other high courts have viewed it. In fact, this question came before the Punjab and Haryana High Court division bench. Then, my lords, Bombay division bench. Bombay division bench also it came.
Yes.
Then my lords, there are another 1 or 2 judgments of the other division benches of the High Courts, which I have placed on record, but I will formulate my viewpoint because since Jagdish Prasad Sharma had been considered in Justice Nagaprasanna's judgment, I did not apply my mind deeper on that.
Yes.
Now that my lords have raised this question, my lords, how question that
in the meanwhile, Mr. Nagarale, Mr. Santosh Nagarale,
my lord,
you will have to place before the court.
Please, my lord.
The enactment under which the Vishweshwaraya Technological University has been established.
Please, I will place.
And in the matter of providing conditions of service to all the affiliated colleges under the university, whether they are bound to follow the directions given by the university or it is left to the institutions. Is there anything contained in your enactment?
My lord, my enactment deals with, my lord, section 40, affiliation of colleges and recognition of institutions, my lord.
Yes.
And then, my lord, section 43A, my lord,
yes,
specifically deals with autonomous colleges, my lord. In none of these sections, my lord, they deal with the service conditions of the affiliated colleges, my lord. The consistent stand of the university is, my lord, that insofar as the conditions of service are concerned, it is for the autonomous colleges to make those rules and follow whatever prescriptions that are prescribed by the state government and AICTE regulations. AICTE is on record. My lords may because AICT has been a party before all the high courts on this issue. They may place on record, my lords, what is the, for example, I know of one judgment of Punjab and Haryana High Court, division bench held that 65 years. Against that, my lords, the review was filed and review was dismissed. Then, my lords, the SLP was filed. SLP was withdrawn as not pressed. AICTE being a common party before all the forums, AICTE will then better position to place on record the interpretation given to these 2019 regulations by various high courts. Now, my lords, I cannot, I can succeed only on one ground, that AICTE is, it is a condition of approval. And one line has been noticed by Lordship Justice S.R. Krishna Kumar, that approval handbook contains a provision that these AICTE regulations are to be followed, but Lordship Justice Krishna Kumar holds it is prospective. Which handbook was for handbook of which year was placed on record? It is not forthcoming. Therefore, let the AICTE say how its regulations have been interpreted.
Yes.
And consistently, my lords, every high court has held in favor of the employees, and only Andhra Pradesh High Court, the matter is yet to be heard. But there also hundreds of stay orders have been granted. This requires some deeper consideration. I quite see that, my lords.
Yes, sir, but as you rightly put it, if the AICTE being a common respondent before all the high courts,
yes, my lord,
in such matters, they should be in a better position to appraise this court.
Yes, that's what in fact.
What are the opinions of various high courts, and if not for the Supreme Court, in the matter of the regulations of the AICTE? This is not the first of its kind. There may be several matters. And the AICTE should apprise you of what is the opinion of various high courts and what is being followed by the AICTE.
Regarding 2019 regulations itself, my lords, regarding the 2019 regulations which I am relying upon, 4 high courts have rendered the judgments. In all of them, AICTE was a party. They should say, my lords, what is the position at all.
Sir, we will hear you. We will hear you. The preliminary submissions that were made, that there are 2 conflicting decisions of this court, and therefore this matter may be sent before the division bench. Only on those submissions I was thinking. Now that I find that there are various other aspects which have not been dealt with in both those decisions, and therefore I will proceed to hear. It's not that even at the later stage, if I come to a conclusion that my opinion will be in supporting in one of those judgments, there is nothing wrong. Yes.
That is what exactly held, my lords, by Lordship Justice Ravindran in Panchayat case.
Second one says it is mandatory.
Yes, yes, sir. No, that's all right. That's all right. You can make your submission. We are not hearing the matter finally. If it has to be that preliminary question that is raised by you, I have gone through, and I am of the opinion that this matter requires consideration, not that it has to be sent before the division bench. That is my opinion. So therefore, you please go on with the merits of the matter, and they'll have to file their objections, taking note of the observations made by this court, that you being the common respondent in all such matters before various high courts and even before the Supreme Court, you will have to apprise the court of the latest position. What is the view on this issue? Huh?
That is granting the final relief and interim status. So where is the application? And he modified that order. He's letting it stay up to the institution. You will not be examined. He will pay.
Why, sir?
As I said, 58 according to our superannuation, he should be at 58.
That's all right. That's all right. But why? No, no. Huh? That's all right. That's all right, sir. We may take about maximum. We may take about 4 weeks to decide the case. Let us decide the case. No, sir. No, sir.
He suffers such an irreparable injury that cannot be compensated. Here, he doesn't suffer any irreparable injury because if he succeeds, he will get back his hand without working. The balance of company also is not in favor because he has, according to our regulations, he has the completed his age of superannuation. So, even if out of the one is in this favor, 2 are against him.
Illa. Even there, I think the balance of convenience would lie in their favor because, say, suppose you lose this case. This person is kept out of service. You appoint some other person. Then what should happen? You please wait for. You please wait for 4 weeks or 4 weeks, sir. Nothing will go. We will decide the matter once for all. Yes. Yes.
What should they do? In fact, in this particular case, the first decision was brought to this notice, but he doesn't consider it. Then he comes to this Pramod's case. Pramod's case has nothing to do with this. For what consideration, what is well it should be there. There is a question of law as to whether as a senior most lecturer in a private public.
But this interim order was granted after hearing by learned friend. Notice was ordered. After notice, they were heard, and then interim order was granted.
The question that came up before consideration, then it is 18 times, the Supreme Court doesn't give any finding whether the superannuation age is 20 or not. Para 18, that was conveniently left out. I will read that. 18. Facts noticed above. And since there is some confusion of lack of assistance of issue age of superannuation from the side of the respondent, and also because there is no discussion on this issue, the judgment under appeal, he refrained from lay down the law in this regard. But doesn't go ahead. How can you apply this? You say this is mandatory. On the face of it, it is wrong. And then finally, because the Supreme Court said state adopted. But itself says it is adopted.
Sir, even in the case of Jagdish Prasad Sharma, as I pointed out, even the UGC regulations are held to be mandatory, but only in the light of Article 309. That distinction. So that distinction was drawn.
After annexed regulations 2019 was made, there was another notification R7. It refers to this regulation to say it's all R7 mechanism 138.
In fact, Article 309 has been considered, my lord, by Punjab and Haryana division bench.
Case of annexed D 2019. Then go on to say. It apply only to 140. In the light of facts narrated in preamble, the government of who has basically in respect to which goes into teaching and working in government, aided institute, college, hospital college, and teaching institute under control department. Some mention about
colleges, unaided colleges. Only government. Another facet of it. See, this very same 19 is considered as a right to right. That is, you only have people to comment and aided institutions, not to a private unaided institution like the respondent. This is the reason why I said this is a matter which consider.
No, sir. We ultimately, if that is the conclusion, then the judgment of this court will be supporting one of those judgments. It will be placed before the division bench.
There are conflicting decisions. You have to perforce place it before the chief or every reference.
Yes, I know. Even in the case of that official liquidator versus Dayanand, Supreme Court has said so.
Either 2013, Karnataka, 2011.
Sir, Supreme Court judgment ಹೇಳ್ತಾ ಇದೀನಿ ನಾನು. Official liquidator versus Dayanand, following the several decisions of the Supreme Court itself, making comments on the decision in Uma Devi's case. Supreme Court came down very heavily, even in respect of the judgments of the Supreme Court. Adene, that's what. There they have said that discipline, judicial discipline would require. Yes.
The second judge came to notice his first issue. They said, order record, place it before you. Same not deserving. The coordinate by decision bench.
But there, in the decision of his Lordship Justice Krishna Kumar, it has gone fully on facts. Their undertaking was given by the petitioners, that was noticed. It was on those grounds. But here, His Lordship Justice Nagaprasanna has gone in a different. ಏನ್ ಹೇಳ್ತಾರ ಅವರು? That is the stand taken by you. So in both the cases, you have taken a stand. In both the cases, you have taken a stand.
Act does not say anything regarding basically superannuation. It is definitely association. I mean, the institution. In both the cases, they are both private institutions. Both of them have rules governing superannuation. Whereas the ACT itself has no. We are not really.
ಅವತ್ತು ಖಚಿತವಲ್ರಿ ಅದು 2010 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಫಿಷಿಯಲ್ ಲಿಕ್ವಿಡೇಟರ್ ದಯಾನಂದ್ ತೆಗೆ.
Page 159, this is the economic side in that case. Okay.
Sir, in that case, Rajgopal Sahebre, if the BTU and AICTE has been the common respondents in both those writ petitions.
Yes, ma'am.
And a stand has been taken by BTU and AICTE. Then we have to hold that there are conflicting decisions.
No,
I
there is no
thought,
such,
I thought this was deemed university. So these also fall on the same category.
My lord, there is no conflict. My lords may kindly take Panchakshari, Virupak.
No, that is trying to distinguish. I don't think I should venture into that one.
No, my lords, there is absolutely no conflict.
If the respondents are common and the issue raised is common, then I should hold
my lords,
that.
the difference is this, my lords. Those were the cases coming under 2010 regulations. This comes under 2019 regulations.
No, that's all right. No, that is not the issue. The issue is whether the age of superannuation can be regulated by the AICTE or not.
My lords, that
is the only issue.
My lord, that has been set. That has been decided by the Supreme Court in Pramod. Therefore, it is not.
Whether this issue is same and it has been considered by both the courts, coordinate benches,
no, both
and there is a
considered.
conflicting opinion.
My lords, AICTE issue has not been considered. AICTE stand has not been considered in either of them.
Allah, not the question of being considered or not. Adalla. If the issue is same and the respondents in both these matters being the BTU and AICTE, there are conflicting decisions.
No, AICTE, my lords, AICTE has accepted both the judgments. It has not gone in appeal. Now,
AICTE is not the aggrieved party here.
Therefore,
AICTE is not the aggrieved party.
My lords, AICTE has suffered the judgment from at Supreme Court in Pramod, which said that it is within its regulations can cover age of superannuation. And the Punjab and Haryana division bench has considered this Article 309 also in some detail, and it has held that because of entry 66 of list 1, the moment AICTE regulations come into force, the state enactments will become void. That is the view taken by the Punjab and Haryana High Court. And that was in respect of a government college. Then Chandigarh Union Territory, it filed a SLP. It withdrew the SLP. Then, my lords, in respect of private education institutions like MS Ramaya Institute of Technology, Bombay Division Bench has held. State has made an enactment like MEPS Act, like our Karnataka Education Act. And these AICTE regulations have come. Article 254(2) will come into play. Interpreting that way, my lords, interpreting both entry 25 of list 3 and entry 66 of list 1. Bombay Division Bench has held that the AICTE regulations will prevail. Now, whether AICTE can fix or not, the AICTE cannot argue against its own regulations. AICTE has made the regulations. That regulations have to be interpreted by laws.
Therefore, can there be two conflicting opinions? One saying no, the AICTE cannot regulate the service conditions. The other saying yes, it is applicable.
That situation did not arise because one dealt with 2010 regulations.
Adalla sir, prashne. That is not the
My lords,
issue.
about the applicability of the regulation, both of them have not said anything. What they have said, 2010 regulations, there is a discretion to adopt or not. That is what Lordship Justice Kumar said. Lordship Justice Prasanna said, under 2019 regulation, there is no discretion. They operate in two different fields. Let there be my lords, on law. Let my learned friend point out one conflicting sentence in these two judgments. 2010 regulations ಅಲ್ಲಿ discretion is there ಅಂತ ಹೇಳಿದ್ರು Sukumar Sahib. That position I am not disputing. 2019 ಅಲ್ಲಿ there is no discretion ಅಂತ, there is what Lordship Justice Nagaprasanna said. There is no conflict. Now,
No, how is it permissible for the AICT to go on changing its stand? One regulation,
no.
no, it is mandatory.
No,
Another one it will say no, you
no,
take your own
regulation
ಮಾಡಕ್ ಬರುತ್ತೆ.
ಅದು ಮಾಡಕ್ ಬರುತ್ತೆ ಯಾಕೆಂದ್ರೆ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಅಲ್ಲಿ 2010 ರೆಗ್ಯುಲೇಷನ್ಸ್ ಅಲ್ಲಿ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ಸ್ ಮೇ ಅಡಾಪ್ಟ್ ದಿ ಸ್ಕೀಮ್ ಅಂತ ಇತ್ತು. 2019 ರೆಗ್ಯುಲೇಷನ್ಸ್ ಅಲ್ಲಿ ಆ ಸೆಂಟೆನ್ಸ್ ಇಲ್ಲ.
There may be a reason for that one, sir.
Like that is AICT has to tell.
That, like what happened in the case of Jagdish Prasad Sharma, during the course of the proceedings before the Honorable Supreme Court, having regard to the peculiar facts and circumstances of the case, there when several states wanted to adopt the regulations because they were getting the benefit of 80% of the salary coming from the UGC, but that would stop after 5 years. So they one side they wanted to have it, on the other side they were thinking of the financial difficulty. Therefore, having noticed all this, UGC recalled that regulation.
Here they have not recalled yet. The AICT has not recalled.
No, that is what. So in the light of those circumstances, probably the AICT also had to recall that.
They have not recalled.
It cannot be a situation where for a particular period the regulation would say it is mandatory, you have to follow the conditions laid by the AICT in the matter of age of superannuation, and thereafter it is given a go by. Angyang ಮಾಡಕ್ ಬರುತ್ತೆ.
2010 ಅಲ್ಲಿ ಡಿಸ್ಕ್ರಿಷನ್ ಕೊಟ್ಟಿದ್ರು, 2019 ಅಲ್ಲಿ they withdrew. In 2019 regulations, there is no such discretion. Jagdish Prasad Sharma case, it came for a mention in K. Gopal's case. Pension matter.
No. It was not after I became a judge. I told you when I was in the first court.
No. Jagdish
I had
Prasad
this
Sharma.
occasion of making my arguments on behalf of the state government.
Jagdish Prasad Sharma, as a judge of this honorable court, deal ಮಾಡಿದಿರ. Gopal pension case ಅಲ್ಲಿ their facts were slightly different. State wanted to rely on Gopal with this Jagdish Prasad Sharma to say that the pension is a condition of service which under the UGC regulations we have discretion to adopt. Therefore, we have not adopted it. Then my lords gave a finding. 23/12/2019 2009 order ತೆಗೆದು you have adopted the scheme. Scheme includes pension ಅಂತ ಬರೆದಿರಿ. Therefore, Jagdish Prasad Sharma is not coming here for the first time. In so far as this regulation conflict between Justice Krishna Kumar and Nagaprasanna is concerned, they consider two sets of different regulations. And
sir, as I said, ultimately the issue is whether the service conditions as given in the regulations of the AICT can be forced upon the institutions affiliated to VTU.
Not affiliated.
That is the only issue. It is not about whether this regulation or that regulation.
The question is
whether the AICT has got that power to impose the service condition, more particularly the age of retirement, on the institutions affiliated to VTU. That is the only question.
Two high courts have
And
held.
if both the courts have dealt with the same issue and have given a conflicting opinion.
No, both of them
then-
have not dealt with that issue. Krishna
Then
Kumar
what was the
Sahib
issue?
Madmilla,
Then what was the issue before the two benches?
Therefore, that issue was not argued before both the benches. Now that issue will be argued for the first time before my lords.
Sir, in both the matters, it was the age of superannuation only which fell for
But this
consideration.
argument nobody advanced.
ಯಾವ argument?
Either whether the AICT can fix the age of superannuation or not.
But that was the issue.
But that is nowhere argued. I'll point out some of the judgments. Nowhere that was argued. What was argued was the college only. Nobody else seriously argued this matter. The colleges, that is one of scaly group of institutions in Professor Dattatreya, they argued that AICT regulations are not mandatory. 2010 alli, it is subject to adoption by the state anta ide ನೋಡಿ ಅಂತ. ಅದನ್ನು ಒಪ್ಪಿಕೊಂಡು ಕೃಷ್ಣ ಕುಮಾರ್ ಸಾಹೇಬರು ಬರ್ತಾರೆ, it is subject to adoption, it has not been adopted ಅಂತ. ನಾಗಪ್ರಸನ್ನ ಅವ್ರ ಮುಂದೆ ಹೋದಾಗ 2019 regulations have come into force. 1.2, 4.2, 12 ಅದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಇಲ್ಲಿ there is no discretion ಅಂತ ಬರೋದು. Both of them went by the language of the particular regulations. For example, my lords, at different points of time, until 1986, UGC pay scales were not made applicable to universities also. Thereafter,
let us see.
Yes, ma'am.
If that is the position,
Yes,
then I will go ahead. Otherwise, if the question of whether the
even if there is
of the AICT,
yes, ma'am. AICT power vishya, power of AICT
has not been dealt with, then I will proceed to hear this matter.
Yes, ma'am.
Let us see. Let us see. This is the earlier judgment of His Lordship Justice Krishna Kumar.
Yes, ma'am.
Yes.
Para 3 ಅಲ್ಲಿ, my lord, stand of the university V2 is there, my lord. Para 4
So,
and
first
5.
of all, what was the question formulated? Huh? One ನಿಮಿಷ ಸ್ವಲ್ಪ ಆನ್ ಮಾಡಿ, ಮೈಕ್ ಆನ್ ಮಾಡಿ.
AICT has specifically stated that its regulations governing pay scale, superannuation, etc., will not come into force automatically, and that since management are the appointing authorities, in case of unaided institutions, the respective management will have to take a decision by making suitable amendments in their respective service regulations. It is also stated that there is an obligation on the part of the institutions to implement the AICT regulations, and if the same are not implemented, penal consequences will follow. Then para 6. AICT.
One ನಿಮಿಷ. Please read it once again.
The AICT has specifically stated that its regulations governing pay scale, superannuation, etc., will not come into force automatically, and that since the management are the appointing authorities in case of unaided institutions, the respective management will have to take a decision by making suitable amendments in their respective service regulations. It is also stated that there is an obligation on the part of institution to implement the AICT regulations, and if the same are not implemented, penal consequences will follow.
All right.
Then the 6th, then page 22, item 2. AICT, which is established under AICT Act 1987, has been conferred with the power to make regulations to carry out the purpose of the Act. Pursuant thereto, AICT pay scale, service, etc., Regulation 2/2010
was notified, which provide for applicability of the scheme. As per the said regulations, it was the respective state governments to adopt and accept the pay scales and applicability to AICT approved institution. In this regard, AICT issued a notification dated 5/3/2010 that I have produced as annexure R4 by Gazette notification dated 7/3/2011, R6 that is, issued by Government of Karnataka in relation to revised pay scale. It was made clear the scheme will apply only to teachers, librarians, physical education personnel, aided and university constituent engineering colleges coming under the control of the Department of Higher Education. It is contended that the revised pay scale was not applicable to private engineering college in the state, including colleges run by KL Society. It is also clear from the aforesaid government order dated 7/3/2011, that is R6, that other terms and conditions of service stipulated in AICT notification have not been adopted for implementation, even in respect of government controlled institution to which they apply, and at any rate, the same would not apply to KL Society and the engineering colleges run by it.
That is the notification issued by the state government.
Yes, that is very clear, Madam. AICT, kindly have a look at this R4 at page 85.
Yes.
I have produced it. That AICT notification.
Yes.
Then para 14 mil at internal page 30. Para 14. As rightly contended by Learned Counsel for respondent, the AICT, which is established under the AICT Act, has been conferred with the power to make regulations to carry out purpose of the Act. Pursuant thereto, AICT as also regulations 2010 was notified, which provide for applicability of the scheme. As per the said regulations, it was for the respective state governments to adopt and accept the pay scale and its applicability to AICT approved institution. In this regard, AICT issued a notification dated 5/3/2010, that is annexure R4, wherein it is specifically stated that the scheme under said regulations had to be adopted by the respective state government by Gazette notification dated 7/3/2011, R6 that is, issued by state government of Karnataka in relation to revised pay scales. It was made clear that the said scheme will apply only to teachers, librarians, physical education personnel, and so on so. Under the control of the Department of Higher Education, the scheme was not made applicable to private engineering colleges in the state, including the colleges run by KL Society. It is also clear from the aforesaid government order dated 7/3/2011 that the other terms and conditions stipulated in AICT notification 5/3/2010 have not been adopted for implementation, even in respect of government controlled institution to which they apply. And at any rate, the same would not apply to KL Society and engineering colleges run by it. Para 16. The material on record also indicates that the claim of the petitioners for enhancement of age of superannuation 58 to 60 is liable to be rejected. In this context, it is seen that the conditional service of employees of KL Society are governed by KL Society service regulations as amended from time to time. The reliance placed by petitioner on the government order dated 10/7/2008 is untenable. I mean, regard to the fact that
we are not concerned with government orders.
Para 17. Para 17 note.
But what is it that the AICT did?
AICT has not stipulated.
Mr. Shauri, what is it that the AICT do after? Huh?
Will not come into force automatically. But the stated that since the management of the institutions are the appointed parties, case of mandated institution, the management have to take a decision to implement the regulation, make it.
You also said that if it is not implemented, penal consequences will flow. What did you do?
Before that, one paragraph was they have.
The affidavit, I have produced that affidavit as an annexure to my statement of objection. R8, R8 ಅಲ್ಲಿ the final objections of the affidavit of the AICT in this case. R8. 157, page 157. They make a reference to the section of the act and then say what are the.
So what has not been dealt is whether the AICT regulations are mandatory.
That is because the AC themselves have said it is not mandatory.
That is not the issue.
Section,
so therefore, we'll have to find out whether the regulations
whether Act provides for prescribing pay scales and superannuation.
Correct.
Whether the regulations
are mandatory.
Yes.
Correct. That is the
regulations, whether they stipulate anything about superannuation age and pay scales. These are the two things, which considered.
That has not been dealt here.
That is because
not raised and not dealt here.
Itself, the AICT affidavit itself.
Our affidavit aktara, that is only the stand of the AICT.
Kindly have a look at the act. Then.
All right. Idaitu. Now we will take the other case.
Yes. Second judges.
Yes.
Para 5 may kindly be seen.
Adrallu probably their stand will be same because they can't take two different stands.
Howdo. Para 5. This is the contention of the petitioner.
In para number 9, the question has been formulated.
Yes. Para 5 don't dive.
Para number 9 alli question has been formulated.
Para 5 nalli kuda kindly just. Para 5. Learned senior counsel appearing petition would raise the following contention. The regulation of AICT are mandatory to be followed by institute on every facet of service condition concerning the employees, which is a condition precedent for grant of approval or recognition by the AICT. The age of superannuation of all faculty members of the institute has to be 65 in terms of regulations of AICT. Petitioner is entitled to continue up to 65 in terms of so-and-so regulation, and the institute being aided in which cases are private institute hardly matters. Para 9 then kindly.
Yes.
I have given my anxious consideration to submission made by respective senior counsel appearing for the petitioner and fourth respondent. The learned counsel appearing with third respondent, AICT and learned additional advocate, government advocate appearing for I have perused the material recording. The point arise of consideration is whether the petitioner is entitled to claim that his age of retirement should be 65 years in terms of regulations of AICT.
Correct.
This is
that is the question formulated.
Yes, formulated.
And whether this
then
question.
Para 14.
Huh?
Para 14.
Para 13 also is relevant.
Para 14. The emphasis in the aforesaid internal page 16. The emphasis in the aforesaid extracted regulations of AICT is that it regulates service condition faculty members regulated by AICT. Regulation 1.2 mandates that it applies to all degree level technical institutions and universities. Regulation 2.12 unequally depicts the age of superannuation of all faculty members, principals, directors of institutes, which would mean degree level technical institutions shall be 65. And the discretion is vested with the institution to extend it up to 70 years. The mandatory nature of direction is in regard to the age of superannuation being 65, and the directory nature regulation is extension to 70 from 65. Therefore, any institution being regulated in terms of regulation 1.2 will be bound by service conditions stipulated in regulation. It is not in dispute the norms.
How regulation is it?
Yes, 2019.
2019.
Yes, 2020 it is clarified that is not brought to his notice. 2009-20 regulation R7 is not brought to the notice, which makes it except that all private unaided institutions are kept out of it. That is not noticed. The 24/3/2020 is the notification which clarifies this point, but that is not noticed in this judgment. That makes all the difference. Para 16 may kindly please. Page 21. Internal page 21, last one. In terms of the delineation by the Apex Court as to what would be the service conditions, retirement is undoubtedly a service condition. Therefore, every service condition that is in the regulation is binding on the fourth respondent. The institute cannot pick and choose what the regulation is. So this is again wrong.
Oh, it is said it is binding.
Unless it is adopted. And
uh,
then they themselves not clarify to say that this is not applicable to government unaided institutions. That is that subsequent notification of 2020, March 20 is not brought to the notice of the government judge.
Where is that?
Judge is very
Where is that now?
That kindly see R7 at page 138.
Why didn't the AICT bring it to the notice of the
state?
We are not concerned with the state notification. We are not concerned with the notification of the state government because anyway it is not applicable to you.
That is because without adoption except
Adoption by whom?
By state government.
Sir, you are saying on the one hand that you don't come under the state government because you are an unaided institution.
Subject to adoption by the very state government, adoption by either a pay scales, which is revised from time to time, and also age of revision. So government has to adopt it. That is in this, while adopting it, this is what this government said, R7.
No.
Right? So speaking, that has
One nimsha. Are you saying that you have adopted the service conditions fixed by the state government?
No.
As of now?
No. What we say is, so far as superannuation age is concerned, the state government has clarified to say that it is not applicable to government.
Adala, we are not concerned about that one.
Please.
As it is. When you say you are an unaided institution, and the state government cannot impose the service conditions of your employees.
AICT cannot impose. That's what
Avuru madak baralla, you state government to madak baralla anta nim stand. Because the moment you say I am an unaided institution, the regulations of the state government to its employees, to the affiliated institutions of the state government, it is applicable only to them. It is not applicable to me because I am an unaided institution. That is your stand.
Yes.
So therefore, why are you now harping upon the GO of the state government?
Every notification has to be adopted.
So it's not that whether you have adopted the regulations of the AICTE.
If the government has to direct, then we adopt. That's all.
Why should the government direct you, sir?
Because ultimately it is mandatory.
You directly come under you directly come under the AICTE.
No, you don't. So far as pay scales, service conditions and superannuation, we don't come under. Because the Act doesn't provide for all this.
Your stand is that you neither come under AICTE nor under the state government.
I say, Lord, AICT does not have a right in respect of prescription of the age of superannuation or pay scales. Government
they have not questioned the
measure of course, as and when the AICT regulates, we adopt it. But so far as superannuation is concerned, we are free. We don't.
You are free both from the AICT and the state government is your stand. Then
I only say, my lord, that so far as pay scales are concerned and age of superannuation, the AICT has no business to interfere.
What about state government?
State government, if he notifies, my lord, we have to adopt because we are, after all, we are obliged to the government to follow certain rules.
Under which mandate?
Education Act. Education Act ಅಲ್ಲಿ notification ಕೊಟ್ಟು ಅಂತಂದ್ರೆ follow ಮಾಡಬೇಕು.
They can.
Under the Education Act.
Every time whether the AICT notifies, once in 10 years, once in 10 years or so, they make an adoption. Then government adopts those. The order is passed without extending it to private unaided institutions. Also, we do it. Government passes an order and then we do it. Until then, it doesn't.
Sir, the moment the government passes such an order, you will contend that who are you? That will be your next stand.
We have been doing it for.
Under section 87 of the Education Act. 87 only. State government cannot control service conditions of unaided education institutions.
Section 87 is the only.
Qualifications, conditions of service of employees.
Yes, ma'am.
State
The
government
state
may,
government may, after previous publication, make rules regulating the conditions of service of the employees in recognized private education institutions, provided that the minimum qualifications for recruitment, age, retirement for the receiving maintenance grant from the state government shall be the same as those applicable for the corresponding categories of employees, if any, in the state institutions, unless otherwise prescribed. Provided that conditions of service of employees working in aided educational institutions shall be as such as may be determined by the government from time to time. Unaided education institutions regulate ಮಾಡೋದಕ್ಕೆ ಅವರು power ಇಲ್ಲ.
ಅಲ್ಲ, it may ಅಂತಿದೆ. It may
Provided further that conditions of service of the employees working in aided educational institutions.
ಅದೇ.
ಅದು this is unaided educational institution. ಅವ್ರಿಗೆ ಫಿಕ್ಸ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
State government may, after previous publication, make rules regulating the recruitment and conditions of service, including rights as regards disciplinary matters of the employees in recognized private educational institutions.
And I'll hear it. Proviso is, second proviso, provided that the conditions of service of the employees working in aided educational institutions shall be as
ಅಲ್ಲಿ shall be.
ಹೌದು.
ಇಲ್ಲಿ ಮೇ ಅಂತಿದೆ.
But they have not made any rules.
Correct.
They have stopped rules from degree. What they did, my lords, under the Right to Education Act, now that up to 14 years of age is compulsory education and equality has been brought about. Primary and high schools fix ಮಾಡಿದ್ರು, rules ಮಾಡಿದ್ರು. PUC rule ಮಾಡುವಾಗ ಏನು ಮಾಡಿದ್ರು ಅಂದ್ರೆ, the salary payable to an employee in a unaided education institution shall be not less than the minimum of the pay scale in government ಅಂತ ಮಾಡಿದ್ರು. Degree and above, they have not made any rule. In fact, in respect of engineering colleges and medical colleges, since they are governed by the AICTE Act and the MCI Act, they have not made any rule. It is easy for them to say, state government ಹೇಳಿದಾಗ ಮಾಡ್ತೀವಿ ಅಂತ. ಇದುವರೆಗೂ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಇಂಜಿನಿಯರಿಂಗ್ ಕಾಲೇಜ್ಗೆ, ಮೆಡಿಕಲ್ ಕಾಲೇಜಿಗೆ ಏನೂ ಹೇಳಿಲ್ಲ. It is only saying that if the state we will say we will do, and as my lord said, state ಹೇಳಿದ್ರೆ you have no authority ಅಂತ next ಬರ್ತಾರೆ ಅಂತ.
Sir, unless the state government adopts it, then
Adopts what?
Adopts the AICT, whatever that they.
Sir, that is, even if it adopts, it will apply it to your. It is the government.
Government-aided institutions only.
Adene, that is not the issue here.
Correct.
Issue is not whether the government has adopted. Issue is whether the regulations of the AICTE is mandatorily applicable to you or not.
Correct.
Ashte.
That is all. Correct. I say unless it is adopted, we can't do it. And then, Millard, as I said, sections 2 of the sections are there. It says whether the Act does not say anything about prescription of salaries or superannuation. It is left to the discretion of the engineering college. This is exactly what the first decisions concern.
So after this 2019 regulation.
Yes. 2020 ನಲ್ಲಿ ಒಂದು ಬಂದಿದೆಯಲ್ಲ ಅದು ನೋಡಿದ್ರೆ.
State, my lord, AICTE has not diluted it.
If it is left to the state ಅಂತಂದ್ರೆ, it's a different issue altogether. We are not concerned with whether the state has accepted it or not. We are concerned with the question as to whether the other part of the regulations which do not bind the state government.
That's why I said, look at the Act itself shows whether that they have not provided for fixation of age of superannuation or prescription salary. Well, kindly have a look at these two provisions. I will just take care of the Act. Kindly have a look at the AICTE Act first.
Yes.
Annexure 2B is the definition. Section 2B is council means All India Council for Technical Education and established under section 3. And thereafter, section 10, chapter 3, powers and functions of the council. Shall be the duty of council to take all steps as it may think fit for ensuring coordinated and integrated development of technical education and maintenance of standard, and for the purpose of performing its functions under this act, the council may undertake so on. Kindly G. Bunny. To all suitable performance appraisal system for technical institutions and universities imparting technical education, incorporating norms and mechanism for enforcing accountability. Now formulate schemes for the initial and in-service training of teachers and identify institutions or centers and set up new centers for offering staff development program, including continuing education of teachers. Next, this is important. Lay down norms and standards for courses, curricula, physical and instructional facility, staff pattern, staff qualification, quality instructions, assessment and examinations. These are the only things that they can formulate. Then this is an omnibus clause. 5. Perform such other functions as may be prescribed. This is the omnibus. Then section 23, 5, in page 8, just above section rule 11. We perform such other function as may be prescribed. Then kindly.
So there is nothing about service conditions.
Section 23, no. 23, power to make regulations. End of para 11. The council may, by notification in the official gazette, make regulations not inconsistent with the provisions of the act and rules generally to carry out the purposes of the act. In particular, and without prejudice to generality of foregoing parts, such regulations may provide for all or any of the following matters, namely regulating the meetings of the council, terms and conditions of service of so, regulating the meetings of executive committee, areas of concern, the region for which the regional committee may be established. Nothing about superannuation age service conditions. Then come to the regulations. So this is the second act. Annexure D, without is the regulation. At page 16 of the read papers. This is 1/3/2019. So the act does not provide for all this. So our contention is that you could not have done it at all because they very well knew, the ACT knew that they don't have power in respect of these two matters.
There is no challenge to the AICT regulations by any engineering college.
Don't interrupting me, Mr. Raj. You have had enough of your say. Let me be free to argue what my case is.
Annexure D.
Annexure D.
Page number?
Page 16 ನಲ್ಲಿ ಶುರು ಆಗುತ್ತೆ. 18.
Which matter?
1.8. This is in the read papers.
18643 na?
1/3/2019. Annexure D to the annexure D to the read petition, page 16.
Annexure D.
Age of superannuation 212. At page 22.
22.
Yes. ಅದಕ್ಕೆ ಮುಂಚೆ 2.11 ನೋಡಿದ್ದೇವೆ page 21.
Yes.
Financial assistance from Government of India for implementation of 7 CPC scale. Central government shall provide by way of financial assistance 50% of the additional expenditure arrears from 2016 to 2019 on implementation of revised pay scale for faculty and other staff such as library, physical education in government aided, state government, autonomous institutions, state universities. That is all. It excludes, specifically excludes private unaided institutions. Then 2.12, page 22. The age of superannuation of all faculty members and principals, directors, institute shall be 65. An extension of 5 years shall till the age of 70 may be given to those faculty members who are physically fit, having written technical books, published papers, and the average is 360 feedback, more than 8 of 10 indicating that they are being active in the last 3 preceding years. This is the power that they don't have, because specifically that section does not say age of superannuation. Now this is going beyond the power that they were given.
So there are two things. Of course, there is no challenge raised, and you say there is no need to raise a challenge to this one. Secondly, that the contention of the petitioners that it is automatically applicable cannot be read into this.
Cannot be read into this. That is why we will kindly have a look at these 3 annexures, which will have bear some light on that. R4 at page 85 of my counter. R4 is 53/2010.
Page number?
Page 85, my counter.
Yes.
Dated 5/3/2010. This is by AICT. Page 94.
2010 regulation.
2010 regulation. 2010. Page 94. ಅಲ್ಲಿ ಏಜ್ ಆಫ್ ಸೂಪರ್ವೈಸೇಷನ್ ಬಗ್ಗೆ ಹೇಳು. Then 96 ಕೆಳಗೆ applicability of the scheme. Page 95 ನಲ್ಲಿ the scheme shall be applicable to teachers in technical institution, other equivalent cadre in so all AICT approved institutions. The implementation revised pay scale shall be subject to acceptance of all conditions mentioned in the letter as regulation framed by AT. So acceptance is to be compulsory. Then 3, the scheme may be extended to all technical coming under the purview of the state legislature, provided state government wishes to adopt and implement the scheme subject to the following terms and conditions. Second one, financial assistance of central government to state government opting to revise pay scales also under section so shall be limited to 80% of the additional expenditure involved in implementation. The state government opting for revision of pay shall meet the remaining 20% of the additional.
That is a different.
Then the entire liability on account of revision of teachers of AICT approved shall be taken off by state government opting for revision of so and so from so opt not to. ಅವಾಗ ಸ್ವಲ್ಪ ದುಡ್ಡು ಬರುತ್ತೆ, ವಾಪಸ್ ಅವ್ರ ದುಡ್ಡು ಬರುತ್ತೆ, ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಬರುತ್ತೆ, ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಬರುತ್ತೆ.
All the government institutions and aided institutions.
Then kindly go to the next annexure R5 at page 101. This is government pay scales. R5 ಮೇಲ್ಗಡೆ preamble. Government of India related so and so pay scale of teaching community of central and colleges based on recommendations also by notification annexure 2. Annexure 2 is R4. R4 what I have just read now by 3/2010. Has examined this issue and has decided to enhance the age of superannuation from 60 to 62 years to a university stage who are drawing AICT pay scales. So extended only to those people. In circumstances explained above, Government of Karnataka are pleased to enhance the age of superannuation of teachers who are drawing AICT pay scale in working universities from the existing 6 years to 62 years, immediate effect. In respect to other teachers working in government, private, aided engineering, the age of superannuation continue to be 60. Then the next is R6, madam. 103. This is in respect of pay scale revision of personnel of government, aided and university constituent colleges in the state under the control of the Department of Higher Education. At 104, item 4, This is again proceedings of the Karnataka government. Government are pleased to revise at the bottom, 104 bottom.
Yes.
Item 4. Government are pleased to revise AICT pay scale in respect of teachers, libraries, and physical education personnel. Government aided university constituent colleges in the state under the control department of so. Again, what is to be noticed is without it excludes private unaided institutions. Next to 138 R7. R7 at page 138. This is the government order which makes a reference to AICT regulations 13/2019, which is annexure D, which I just now read with your lordships, which is an annexure to the writ petition, based on which the petitioner say that the age of 24/3/2020. This is not noticed by the second judge. They refer to item 3 is that annexure D 13/2019. And the final is at 147. Lordship gets item 10 at page 147. The age of superannuation of teachers and other equivalent cadres, government aided degree level engineering college and other degree level technical so shall be in accordance with the rules or issued and shall be regulated as notified by the state government from time to time. Further, if the situation warrants, necessary steps may be taken to re-employ academic staff with prior approval of the state government, which shall strictly be in accordance with the provisions stipulated from time to time, the provisions. It's only applicable to government and aided degree engineering. Yes. So therefore, without so far as these two items are, especially superannuation, without the AICT does not have. That is why there is a lot of so far as payment of financial aid in respect of pay scales which are revised from time to time. Government adopts because they get some. The central government also gives some. So therefore, there is absolutely no specific entry pertaining to superannuation. And therefore, what I would say is it is not at all applicable to an education institution which is private and unaided. And both the judgments specifically dealt with age of superannuation and applicability of AICT. And the Pramod's decision, my lord, I have said.
No, let us not go into all those.
Both judgments dealing with age of retirement. And Pramod's judgment is not at all applicable because the question, in fact, that was left open. Para 18 Other that's because the confusion they don't even say, Supreme Court says, no, I will not deal with it. But they give relief because this man had retired during. So the question was whether he should be promoted. And the state government had adopted the rules. That they gave relief, monetary relief was given. And then even though he had retired, the court had ordered that he should be paid until 65 years, he should be given salary. And that was the financial benefit that the petitioner got. So both these decisions, without I would request subject are in conflict with each other. And those decisions which are the lengthy judgment, the division bench decision of this court have given the citation. In one other judgment also.
If I am given citations, I will keep the books and argue.
Judicial discipline ಬಗ್ಗೆ ಅಷ್ಟೇ ಇನ್ನೇನು.
Yes.
Judicial ಅದ್ರ ಬಗ್ಗೆ
ಒಂದಿದೆ ಇನ್ನೊಂದು again division bench decision with ILR 2012 Karnataka 5-4.
That is also regarding precedent.
The first decision, the relevant paragraphs are from para 40 to 59. They consider all these things. Then in second decision, just Vikramjit Singh, para 4. What is it? Second.
This is what has been said.
Please.
Judicial discipline is self-discipline. It is an inbuilt mechanism in the system itself. Judicial discipline demands that when the decisions of a coordinate bench of the same High Court is brought to the notice of the bench, it is to be respected and is binding, subject, of course, to the right to take a different view or to doubt the correctness of the decision. And the permissible course then open is to refer the question or the case to a larger bench. This is the minimum discipline and decorum to be maintained by judicial fraternity. So we will send it to the larger bench. Sir. Anyway, it is before the larger bench now. Rajgopal Sahib, we will send it to the larger bench.
Larger bench already notice division.
Whatever. Because the essential question that has been dealt with in both the matters is one and the same. Whether the regulations provided by the AICTE would be automatically applicable to unaided institutions.
That is not
mandatory. Mandatory to be followed.
Mandatory to be followed.
May I make
not
this
the question dealt in both the cases?
May I make
and
this
the judges have taken a different view.
Judges
of course, you may point out that in the first case it is gone only on facts. In the other cases, though, the issue is
no, that's I'll kindly bear with. 2010 regulations Mr. Ramdas himself has produced.
Yes.
That says it is subject to adoption. 2019 regulations I have produced. There is no such paragraph which says that it will come into force only on their.
Correct. So therefore, the question is whether it is mandatory to follow the regulations of the AICTE, and it is mandatorily binding upon the unaided institutions affiliated to VTU. That is the question that has to be answered.
No, on the plain language of the regulations, it is mandatory. And you yellow service conditions illa anta. I'll point out, kindly take the UGC Act. UGC Act there is the standards of education anta. Standards and conditions of education, Supreme Court interpreted. It is wide enough to include service conditions also.
I am very clear in my mind. It is not only in respect of a particular regulation. It is the right of the AICTE or the authority of the AICTE.
Yes.
Whether it could direct the service conditions stipulated by it to be imposed upon the employees of the unaided institution. That is the question that has to be answered.
In the University Grants Commission Act also, Section 26, which empowers making of regulations, does not specifically refer to service conditions. What it says is regulating the maintenance of standards and the coordination of work or facilities in universities. That clause has been interpreted by the Supreme Court to include service conditions. Identical clause there is here in clause I, which may then read out. Lay down norms and standards for courses, staff patterns, staff qualifications, quality instructions, assessment and examinations. Quality instructions only. There cannot be quality on an empty stomach. There cannot be quality with inexperienced teachers. All those things are included in this quality that Supreme Court has already taken a view.
Now, let me not add to the confusion by making another judgment.
Confusion is 2010 regulations.
They have taken a stand that it has not been adopted.
AICTE also took
what can we say, sir? After having formulated the regulation,
they say that it is not binding on anybody.
ಅವರೇ ಆ ತರ ಸ್ಟ್ಯಾಂಡ್ ತಗೋತಾರೆ.
Except the printing press, because our payment ಆಗಿದೆ. That is the reason why.
$44. Sorry. ಅದೇ this is Nagara Prasad ಅವರು. ಅಲ್ಲಿ did you find out whether there is any appeal preferred on the other matter?
ಯಾವುದು?
ಕೃಷ್ಣ ಕುಮಾರ್ ಸಾಹೇಬ್ರದ್ದು.
ಅದರಲ್ಲಿ ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿ ರಿಟ್ ಅಪೀಲ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ.
ಅದ್ರಲ್ಲೂ ಆಗಿದೆಯಾ?
ನಾಗಪ್ರಸನ್ನ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ. ನೋಟಿಸ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬೀನ್ ಆರ್ಡರ್ ಯೆಟ್.
That is in Dharwad.
What about against Lordship Justice Krishna Kumar's order? Writ appeal has been preferred, notice has been ordered.
ಕರೆಕ್ಟ್. ಹಂಗಾರೆ ಎರಡರ ಮೇಲೂ ಆಗಿದೆ. ಎರಡರ ಮೇಲೂ ಆಗಿದೆ ಹಂಗಾದ್ರೆ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ದಟ್ ಈಸ್ ಮಲಾಡ್ಸ್ ಕೃಷ್ಣ ಪ್ರಸಾದ್ ಕೃಷ್ಣ ಕುಮಾರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ದಿ ರಿಟ್ ಅಪೀಲ್ ಈಸ್ 100187 of 2021. Notice has been ordered on 8/12/2021. Dharwad bench ಅಲ್ಲಿ. ನಾಗಪ್ರಸನ್ನ ಅವರ ಆರ್ಡರ್ ಮೇಲೆ
Dharwad bench, I think. That is in Dharwad bench.
ಕೃಷ್ಣ ಕುಮಾರ್ದು ಧಾರವಾಡ ಬೆಂಚ್.
ಕರೆಕ್ಟ್.
ನಾಗಪ್ರಸನ್ನ ಅವರ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ 1308 of 2021. Writ appeal is filed in this court before this bench. Notice is not yet order.
All right. Yes, sir. As noticed on the earlier occasion, the learned senior counsels, Sri P.S. Rajgopal, appearing for the petitioner in WP number 15024 of 2021, and the learned senior counsel Sri S.S. Ramadas, appearing for respond number 4, institution, have submitted that on the very same issue regarding the applicability of the regulations of the AICTE in the matter of enhancement of the age of superannuation from 60 to 65. Whether the same would apply automatically to all the institutions, all the technical institutions under the control of the AICTE has fallen for consideration before two coordinate benches of this court. So, the first decision was rendered in petition number 106179 of 2018 and connected matters, decided at the Dharwad bench on 8th of December 2020, holding that the respondent institution therein has not implemented the AICTE regulations, and therefore the employees of the said institution cannot be permitted to contend that their age of superannuation stands automatically extended from 60 to 65 years. On the other hand, in a subsequent decision, in writ petition number 15421 of 2020, dated 24th of May 2021, another coordinate bench of this court has held that the regulations of the AICTE, more particularly in the matter of enhancement of the age of superannuation, is applicable to the respondent institution therein, and therefore it was held that the petitioner therein was entitled to continue in service till he attains the age of 65 years. So, next para. It is also to be noticed that the AICTE and Vishweshwaraya Institute of Technology, Vishweshwaraya Technological University, are party respondents in both those matters. So, in both those matters, the AICTE has taken a stand that its regulations, more particularly in the matter of the service conditions, which includes the age of superannuation, is not automatically applicable to the institutions. Full stop. It is the AICTE has taken a stand that the regulations are required to be adopted by the institutions. Full stop. Next para. It is given to understand that in both those cases, intra-court appeals have been preferred, and the writ appeals are pending consideration, both at the Dharwad bench and the principal bench. Full stop. Next para. In the matter of judicial discipline to be maintained by the courts, though there are several decisions of the Honorable Supreme Court, this court would like to notice the observations of the Honorable Supreme Court in the case of Official Liquidator versus Dayanand and others, bracketly 2008 10 SEC page 1. It was noticed that there have been several instances of different benches of the high courts not following the judgments or orders of coordinate and even larger benches. Stop. In some cases, it was held that the high courts have gone to the extent of ignoring the law laid down by the Supreme Court without any tangible reason. Stop. It was also noticed that there have been instances in which smaller benches of the courts have either ignored or bypassed the ratio of the judgments of the larger benches, including the constitution benches. Stop. Quoting from Mahadev Lal Kanodia versus Administrator General of West Bengal, AR 1960 SC 936, paragraph number 19 was extracted as under. Page number 52 only there. Extract not from this. Only for the benefit of all of us, I will just read that paragraph. If one thing is more necessary in law than any other thing, it is the quality of certainty. That quality would totally disappear if judges of coordinate jurisdiction in a high court start overruling one another's decisions. If one division bench of a high court is unable to distinguish a previous decision of another division bench and holding the view that the earlier decision is wrong, itself gives effect to such that view, the result would be utter confusion. The position would be equally bad where a judge sitting singly in a high court is of the opinion that the previous decision of another single judge on a question of law is wrong and gives effect to that view instead of referring the matter to a larger bench. In such a case, lawyers would not know how to advise their clients, and all courts subordinate to the high court would find themselves in an embarrassing position of having to choose between dissenting judgments of their own high court. Next paragraph number 18. In Lala Shri Bhagwan versus Ramchand, AR 1965 SC 1767 was also quoted as follows. Next para. In Kalyan Lal Bhatija versus Collector Thane, it was held, inverted commas open. In our system of judicial review, which is a part of our constitutional scheme, we hold it to be the duty of judges of superior courts and tribunals to make the law more predictable. The question of law directly arising in the case should not be dealt with apologetic approaches. The law must be made more effective as a guide to behavior. It must be determined with reasons which carry convictions within the courts, profession, and public. Otherwise, the lawyers would be in a predicament and would not know how to advise their clients. Subordinate courts would find themselves in an embarrassing position to choose between the conflicting opinion. The general public would be in dilemma to obey or not to obey such law, and it ultimately falls into disrepute. Lastly, it would be profitable to quote another decision of the Honorable Supreme Court in the case of UP Gram Panchayat Adhikari Sangh versus Dayaram Saroj, wherein it was held as follows. Extract ಮಾಡ್ಕೊಳ್ಳಿ 26 ಅಂತ ಹಾಕಿದ್ದಾರೆ, page number 56 ಅಲ್ಲಿ, para number 88. Judicial discipline is self-discipline. It is an inbuilt mechanism in the system itself. Judicial discipline demands that when the decision of a coordinate bench of the same High Court is brought to the notice of the bench, it is to be respected and is binding, subject of course, to the right to take a different view or to doubt the correctness of the decision, and the permissible course then open is to refer the question or the case to a larger bench. Full stop. This is the minimum discipline and decorum to be maintained by judicial fraternity. Close note, comma. Next para. Having regard to these judicial pronouncements, it is incumbent upon this court to refer the matter to a larger bench. Full stop. Now that there are two writ appeals pending consideration, one at the Dharwad bench and the other before the principal bench, in the form of a writ appeal number ಹೇಳಿದ್ರಲ್ಲ ಅದು ಹಾಕೊಂಡು registry is directed to place the matter before Honorable the Chief Justice, to place the matter before a larger bench, to consider the conflicting views expressed by two coordinate benches of this court. Full stop. Yes.
Second set on the. We have to file second set for the time limit of the fixed model.
Second set has to be filed.
In the meanwhile, the learned counsel for the petitioners in all these matters, adunu ಸೇರಿಸ್ಕೊಂಬಿಡಿ, serial number 44 ಅಲ್ಲಿ ಇರುತ್ತೆ, are directed to file the second sets.
Respondents ಹಾಕ್ಬೇಕಾಗುತ್ತೆ ಅವರು.
Full stop. Similarly, the respondents
ಅವ್ರದ್ದು pleadings ಏನಿದ್ರು, they will also have to file the second set.
I don't think it is. I don't think any of them have filed a statement of objection.
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು, ಮಾಡಿದ್ದೀರಾ?
ಅಂದಾಜು 100 ಪೇಜ್ ಹಾಕಿದ್ದಾರೆ.
Similarly, if statement of objections are filed at the hands of the respondent, they too shall file the second set in order to enable the matter to be placed before the larger bench. Full stop.
Application which I have filed for vacating stay.
ಅದು ಅಲ್ಲೇ ಮಾಡಬೇಕು. ಅದೇ ನೀವು ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ Of course, ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ.
So that it is referred, you have to only move the division bench, not here. Sir, we are grateful, my lord, for a very kind and with lot of research. Your lordship has done a lot of research in this aspect.
ಇಲ್ಲ ಅವತ್ತು ನಾನು ಕೇಳಿದಾಗಲೇ I felt this was something that I had heard when I was there in the first court, and then in fact I can divulge. I discussed this matter with His Lordship Justice Nagaprasanna. He also remembered that both of us had argued that matter before the first court. That Jagdish Prasad Sharma we quoted, and we had argued the matter before the first court.
Oh, in the first court.
I argued for the state.
This is from our court.
Illa, in some other matter, this was quoted.
This was quoted.
Yes. All right. All other matters next week.
May make a submission.
44. ಅದೇ ಅದನ್ನ ಸೇರಿಸ್ಬಿಡಿ ಅದ್ರಲ್ಲಿ.
May make a submission.
Wherever interim orders have to be extended, you please mention it to be extended.
Serial number 36.
All other matters will come up next.
36 million 2011 matter. It could not reach even today also.
ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ.
Date ಕೊಟ್ರೆ ಮತ್ತೆ ಬರಲಿ.
ಇಲ್ಲ ಹಂಗೇನಿಲ್ಲ.
2011 matter.
2011 matter ಬಂದೇ ಬರಬೇಕು. There is no doubt. ಬಂದೇ ಬರುತ್ತೆ. You are party in person in some matter. Serial number 31. Then we'll see. I'll give a date. Serial number 31. Release this matter on 24th of March.
May make one submission, Lord. May make one submission.
ಬರುತ್ತೆ ಅಲ್ಲ 24th ಬರುತ್ತೆ.
Lord, one submission.
All other matters will be listed next time.
Serial number 35 li granting it cancel ಆಗಿತ್ತು. We are impleading applicants. Completing application allow ಆಗಿದೆ. Salary payment ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. 2 years.
ಸರಿ ಏನ್ ಮಾಡ್ಬೇಕು ಇವಾಗ?
ಅದು ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಅಂತ ಇದೆ ಸ್ವಾಮಿ. ರೀಚ್ ಆಗ್ತದೆ.
ಬರುತ್ತೆ ಎಲ್ಲ ಬರುತ್ತೆ. We will see.
Hearing an IR
it will come next week.
My lord.
No. According to it. Yes.
Repatriation, sir. Pictures are 45.
Court officer. Court officer.
ಹೇಳಿ ಸರ್.
ಸರ್ ಇದು 34, 52, 53, 54 ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡ್ಬೇಕು.
ನೋಡ್ಬಿಟ್ಟು ಮಾಡ್ತೀವಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 34, 52, 53, 54 ಸರ್.
ಆಯ್ತಾ ಮಾಡ್ತಾರ.
ಥ್ಯಾಂಕ್ ಯು
Sir. 24. If it is again 30, 31, I will not be able to be heard. 24 serial number. It's my prayer. The respondent.